Okay. 3 days are left for my lord argument. Your lordship, when was in the my lord circuit bench, the coordinate bench admitted and placed before your lordship for interim order, uh, because that was on.
It is not been extended.
Which interim order has been kept for your lordship. She is a cancer patient. She was forced to depose, and we made an application for handwriting expert earlier.
Give it.
That
What
was
do you want?
rejected.
You want
Yeah,
early
I have
hearing
given. I have given the my lord order so that, and my lord kindly to be mentioned. We have also served copy in terms of the direction of the doctor. It is to be mentioned, my lord kindly. Otherwise, it will be infractious.
Non-prosecution give it to be mentioned দিয়ে দেবেন non-prosecution non-prosecution এটা upgrade দিয়ে দেবে
This matter, my lord, I have mentioned this matter before also. My lord, you lordship accepted my application. The upgradation because you lordship may recall, my lord.
Please give the dates. If you don't give the lower court date, I will not be able to understand.
Yes, my lord.
The next date.
I have the date have given, my lord.
Please give it. According to that only I am upgrading. Please give it.
There are two upgradation matter. Very urgent matter, your lordship.
If the dates are not given, I will not be able to upgrade. Please write your dates so that it can be made known to the court that it is so urgent that it cannot wait till after the vacations. I will then take it up. Otherwise, not.
I have given my lord date, my lord, earlier I mentioned it, my lord.
Correction দিয়ে দিন ওনার কি correction.
With regard to item number
Disposal, extension of interim order, withdrawal. Onar withdrawal to be mentioned.
May I have your lordship kindly?
Your lordship. Very in a suit for declaration.
Please write it and give it because at this time I will not hear arguments.
May I have your lordship kindly to mention one typographical mistake? The order passed
mistake,
12 feet
If
without
the slip, write for to be mentioned.
Liberty to mention for inclusion in the list, my lord.
already I have mentioned one matter, my lord.
Write your grounds and give it.
Yes.
Liberty to mention for inclusion in the daily list, my lord.
May I have to mention an application for upgradation, lordship?
Upgradation, please write your grounds. I have been saying this morning, please write your grounds, give it. If I see that there is a date fixed before the trial court which is going to impair your rights, I will upgrade it immediately. Otherwise, it will wait till after the vacation.
Vacating has been passed by the learned additional district magistrate.
Is my voice not reaching you? Sir, please write it and give it.
Your lordship.
Then please don't mention. I will accept it only if you give it in writing, explaining what is it. Because if I accept one, I'll have to allow everybody to make oral mentioning, which will consume court's time unnecessarily. Please write it. Matters are being upgraded on the basis of what has been written here.
Lordship, this is that matter where there is no other side regarding that substitution matter, Mr.
Very well. After the vacation, it's not that urgent.
Item 151 was very urgent, but third time your lordship mentioning. It is there for order on night.
Lordship had heard this, vacating application, possession has been taken.
Lordship, praying for leave to file without a certified copy.
When was the order passed?
Yesterday, the final order was.
Final order?
The final order, Lordship, this is with regard to an internal committee under the POSH Act, Lordship. The final order, Lordship, of the POSH Act, whereby I was given a
POSH Act?
Prevention of sexual harassment at workplace.
Very well.
Because Lordship,
Leave to file without certified copy.
I am very grateful.
You have applied for certified copy.
My lord, since this is an internal committee's order, Lordship, they
But
do not.
still you are
They send it through email.
leave to file without certified.
My lord, may be permitted to mention our upgradation. The next day,
Write your grounds and give it.
it is on tomorrow, my lord. Because
My lord, subject to pleasure and convenience of your lordship.
Yesterday, I myself,
May I mention
as usual, have gone through all these
Item-
slips. Wherever dates were mentioned for 16, all of them have come. All of them have come. If you don't write it properly, you wait for the court to hear your oral mentioning, sir, you are at a loss.
I didn't sleep. My
All
lord,
the matters where dates were mentioned, I have upgraded.
my lord, subject to pleasure and convenience of your lordship, may I mention item number
Item one has been
210?
called.
210.
One has been called, please wait.
My lord, the petitioner, my lord, father of the petitioner, my lord, expired in a motor accident, my lord. My lord, kindly come to page, my lord, annexure A. First, my lord, the application filed by the petitioner along with her mother. My lord, Tuli De is my mother. Ekta De, being minor, filed this, my lord, application before the tribunal. My lord, it was filed, my lord, 2021. Thereafter, my lord, the cause of action, my lord, the parties of the proceedings, that is the petitioner and the opposite, all are Calcutta jurisdiction. In spite of that, due to wrong advice, it was filed before the Surrey court, my lord. Since long, no step was taken. I inquired from the learned advocate, but it came to my knowledge that no step was taken. There was one negotiation was going between the Bajaj Alliance company and the claimant. The petitioner asked for no objection from the learned advocate. That was refused. Kindly come to my application before the tribunal, page 21. I applied before the tribunal for engaging of my fresh learned advocate after getting major, my lord. Because minor, my mother was one, I was two, my lord, represented by the one learned advocate. Being major, I wanted to my lord, engage my fresh advocate. That was rejected on the ground that since my lord, no objection granted by the earlier advocate on record, and also there was a resolution of the Surrey bar. That is why the fresh vocalodna could not be accepted. My lord, problem is this, my lord. Minor was represented by the learned advocate. After getting major, I have every right to engage a fresh advocate. That was prayer before the learned tribunal.
During pendency of the application, you have become major.
Yes. Yes, I kindly come to page 28, 29. 29, my lord.
Yes.
Before that, my lord, my application is page 21.
Your application at page 21 is
21.
is
An
the-
application on behalf of the petitioner, Ekta De, that is petitioner before lordship, praying for allowing
Ekta
her.
De is presently how many years of age?
My lord,
20 years.
yes, my lord, she got measured, my lord, on my lord, 21st January 2024. I have stated in my lord,
January?
21st January 2024. My lord,
And the order which you have impugned is 25th of February 2025.
yes. Before that, my lord, I wrote the learned advocate. That is, my lord, I annexed all the documents, page 29.
So why
My lord,
have you come after 1 year?
no,
From-
my lord, it was pending. My lord, it was pending because since the learned advocate refused to give my lord, no objection, I have to follow the procedure. Page 29, I have annexed everything. My lord, I wrote to the letter to the Surrey Bar Association for.
I see you have filed an application before the trial court for recalling of the order dated 25th February 2025.
My lord,
What happened to that
yes,
application?
my lord, kindly come to last order. That was rejected. The first order is page 20. Order dated 15 10/9/2024. First order. My application was filed for engagement of a learned advocate. And last order.
So where have you explained the delay in approaching this court?
No, my lord, there is no delay as such because my lord, there is no delay. My lord, lastly, my lord, it
The
was
order
filed
which
2025. It was my lord, the civil revision. Two civil revision was filed. My lord, another was filed by my
filed in 2025.
my lord, one transfer application also pending. My lord, one section 10. Yes.
What is the next case? Next stage here?
My
What
lord,
is happening in the
my lord, for issuance of notice upon the opposite party for the company, my lord, Bajaj Alliance to appear.
When is the next date?
Next date, my lord, that is 21st, my lord.
21st of?
So, my lord, 19th, sorry, my lord, 19th May, that is the next date, filed before the my lord, tribunal for ex parte hearing on behalf of the petition number 2.
The
Maybe
দেখে নেবেন তো দিদি, ইনি বারবার বলছেন অ্যাসাইনমেন্টের অর্ডার আমি কিছু পাইনি, আপনি দেখিয়ে দেবেন, দেখাবেন। ইয়েস, প্লিজ কল নেক্সট ম্যাটার।
একটু দেখে নেবেন। এইটা নিন, আইটেম নাম্বারটা লেখা আছে। সরি, এইটার সময় একটা ট্যাগ হবে।
ট্যাগ হবে না, যদি না অ্যাসাইনমেন্টের অর্ডার থাকে ট্যাগ হবে না, দেখে নিয়ে তারপরে
Yes, ma'am.
ট্যাগ করবেন না, একসঙ্গে লিস্টে দেবেন
One.
যদি থাকে, দেখিয়ে নেবেন আবার। নেক্সট।
Grateful.
দেখি। None appears for the petitioner. List this matter.
Item 3, my lord, I appear for the petition.
I'm opposing this application on preliminary on the ground of maintainability.
আপগ্রেডেড কেন দিলেন? কি দিয়েছেন? কিসের জন্য? কি কবে ডেট আছে?
Lord, I'll indicate the urgency, my lord. This is a matter, my lord, where we have in between.
তাতে কি হয়েছে?
An order refusing to
দেখিয়ে তো দেবেন।
stay an preliminary award. An order refusing to stay a preliminary award against which there is no appeal under the Arbitration Act.
Lord, I'll-
And your lordship is aware that the Supreme Court has held only in exceptional circumstances.
This is an exceptional circumstance. I'll demonstrate that, my lord. This is an exceptional
I will
circumstance.
show the conduct.
My lord, this is a dispute, my lord, between the petitioner and the respondent. Lord, my lord, kindly permit me to just give a background. Dispute between the petitioner and the respondent in respect of a partnership firm. The dispute started, my lord, from 2014-15. My lord, there was a family settlement. Under the family settlement, my lord, there was an obligation of both the partners to comply with certain obligations. My lord, ultimately, the partnership firm, my lord, was converted with the consent of the respondent, my lord, into a company in 2021. My lord, in between, my lord, this aspect, my lord, of conversion.
My lord will kindly, because I tell your
I'll
lordship,
indicate.
today is the
I'm the
date fixed.
petitioner. But I'm for the petitioner, my lord. Will kindly. Yes, the urgency is, my lord, without hearing me, my lord, the learned arbitrator had, my lord, proceeded in pass. Proceeded to, my lord, yes, my lord, proceeded to pass an interim award. Interim award passed, my lord, we had challenged that by filing a section 36 application. My lord, the learned commercial court, my lord, in my application in the section 36, my lord, refused to, my lord, take into consideration, my lord, the fact that I was not even heard. And the urgency is, in view of the preliminary award, today the learned arbitrator is proceeding to pass the final award. My lord, reason being that you did not, my lord, there was a preliminary award, my lord, which was passed, my lord, which affects. He's proceeding, my lord, proceeding to pass a final award. My lord, the interim award. Yes, my lord, I'll just satisfy on that. My lord, the interim award. My lord, will kindly, my lord, my 36 have to be, my lord, considered because I had made out a ground. That's my challenge. I'll show the impugned order. The order, yes, my lord, will kindly comes to, my lord, page 30, my lord, 36, volume 1 of my petition. Now, this is an order dated 19th February 2026. Yes. Lord, if your lordship sees, my lord, at the next page, my lord, 37, paragraph 3, my specific contention is, my lord, it's a certified copy, my lord. May I just refer to the certified copy? My lord, it's at the first page, my lord. Yes, my lord, internal page 2. Your lordships will kindly see the third paragraph. My lord, that's my contention before the, my lord, learned commercial court. The contention of the petitioner seeking for stay of the preliminary award is based on the ground that the learned arbitral tribunal, without giving due opportunity of hearing of the petitioner in the said arbitration reference, hastily passed the aforesaid award merely on the case of expiry of its mandate. Now, that was the specific ground. The learned arbitrator proceeded to pass the preliminary award because his mandate was coming to an end. Despite, my lord, there is a provision that parties can by consent, my lord, extend it. My lord, thereafter, my lord, will kindly seize the internal page 4. Lord, page 34, your lordships will see the third, my lord, internal page 4. My lord, will kindly see this third last paragraph. More so, considering the facts and circumstances of the instant case, as well as considering the materials on record, it appears that the urgency as pleaded by the petitioner in respect of getting an ex parte ad interim order is not so satisfactory in my considered view for proper adjudication of the dispute. My lord, your lordships will kindly, my lord, grant me leave. My lord, my senior is appearing.
My lord, if your lordship takes up the matter at 4:25 in the afternoon.
No,
Not this matter. Just giving an example. 4:25, your lordship takes up the matter and says, finish it. It's not possible to argue in 5 minutes. Then your lordship, my lord, decides the matter and delivers judgment. Only thing that happens is the sanctity of an oral hearing, my lord, goes out of the window. My lord, we have the fullest faith in the learned arbitral tribunal. My prayer when I argue the section 34 will be for an order of remand to go back before the same learned arbitral tribunal. I may win, I may lose, I'll get justice. But what happened in this case is, Lord, number one, there is no partnership firm in existence. According to me, there is an oral family settlement, and my learned friend, Lord, retires from the firm and he gets, Lord, other immovable properties. Subsequently, there is a further reconstruction of the partnership deed. Then the partnership, my lord, is converted into a company. 5 or 6 years later, he gives a notice and he dissolves the firm. I say that the firm is no longer in existence. For 6 years, you've obviously acted upon your retirement, because after that, all documents are signed by me, all, my lord, financial results, etc., are all signed by me. So there is no firm. He files a section 9, gets an ex parte order, learned arbitrator is appointed. We go under section 17, and I say that A, this is infructuous, and B, you have paid for certain reliefs against the company. The firm has got converted into a company after your retirement. Me, my wife were there, we converted into a company. There's no firm in existence to be dissolved. Learned arbitrator holds that it's not possible to pass any order against the company. Section 17 order is clear. Then we go into arbitration. A preliminary issue is framed by the learned arbitrator. Is a notice in writing required? My lord, we satisfy, my side, my lord, I had appeared, we satisfied the learned arbitrator on that issue. When that came to an end, my lord, 2 days of hearing, when that came to an end, we suggested, both of us, the matter should be settled. Two brothers fighting, it should be settled. I mean no discredit to the other side. I mean no discredit to my side. My lord, both parties were discussing settlement. Matter kept getting adjourned. Learned arbitral tribunal has, my lord, this notion that his lordship, having regard to his lordship's, my lord, desire to do justice quickly, will never permit a section 29A for extension of time. Now, our adjournments resulted in a situation where his lordship only had limited time. His lordship, my lord, we said we want to file a 29A. His lordship said, no, I'm going to finish it off. We didn't get a proper chance to, my lord, argue. I remember we were in court. His lordship would say 1:15, 2 o'clock, etc. At the same time, parties were trying to work out a settlement, which ultimately didn't happen because His Lordship, my lord, on virtual mode took up the matter 1 or 2 times. We couldn't even argue. I don't remember arguing on merits. There is an award passed holding that. Learned court, my lord, please see the order impugned once. Kindly see the impugned order. Lord, please come to, my lord, page 2 of the impugned order. 3rd paragraph. This is, my lord, 2nd paragraph. This is exactly what, my lord, I have submitted before your lordship. Third paragraph, the contention of the petitioner seeking for stay of the preliminary award. Yes, my learned friend, space, please, my lord. Now, my lord, second last paragraph, 2 judgments which we had cited, that without there being oral hearing, there can't be a final conclusion. Those judgments, my lord, we cited. Now, my lord, please come to the next paragraph. It is fact that the petitioner has filed the instant miss case under section 36(2) of the Act praying for stay of the award, however, has not caused file any application under section 34 of the Act. That's not correct. Unless I file a 34, how can I file a 36? However, on perusal of the preliminary award, it appears that the arbitral reference, that before the arbitral reference, the contentions of the petitioner being the respondent was twofold. One is the claim of the respondent is barred by limitation, and prior age of the statement of claim is illegal, null and void, is not arbitrable issue before the learned arbitral tribunal. However, the learned arbitral tribunal hold that prior age cannot be decided by the arbitral tribunal on the ground as stated in the award, and in respect of limitation point, learned arbitral tribunal considered to hold the same after going into the evidence. Then the learned arbitral tribunal framed 4 issues. Then both parties decided that in respect of the issue, oral evidence is necessary. Then parties led evidence. And then my lord, kindly come to the reproduction from the 29th sitting at the end. It appears that this tribunal's mandate is going to expire on 3rd March 25. It is not possible to grant further 7 weeks' time. Therefore, this tribunal wants to pass a preliminary award on the question whether in the absence of notice of retirement of section such and such, it is legally possible. Be that as it may, if the parties decide to amicably settle their disputes, the tribunal cannot stand in their way. And then, my lord, award was passed. But thereafter, the tribunal intended to hear the parties. Urgency now is learned arbitral tribunal is fixing dates. He wants to proceed further and pass a final award. Issue is, my lord. Yes, subsequently he had it extended.
We filed it.
It's filed and pending. So now this is the problem. Now please see.
No, my lord. I'll tell your lordship why. My lord, I will take just. My lord, I will just take 5 minutes. My lord, absolute incorrect submissions.
The first week after
absolute incorrect submissions, my lord. My lord, kindly gives me 5 minutes. This is a way to stall. My lord, kindly takes volume 7.
Waited for so long.
No,
court is shutting down.
No. That one state, volume 7. My lord will kindly take volume 7. My lord, I'll just take 5 minutes. I'll just take 5 minutes. My lord has heard my learned friend. My lord kindly takes.
Don't even pass an order. Both of us can play for one adjournment.
Kindly
and the first week after vacation, we will
volume 7, page 1146. 17th February 2025, 1146.
May I read this problem? 1 minute, just last sentence.
কত? I think it's volume 9.
Just one more sentence. The learned arbitrator has asked us to have accounts taken of the firm. My case is there is no firm, it's gone.
No, that's
So, my lord,
different.
it's
That's
a
on the merits.
infructuous
If we
exercise.
want to argue, we can argue for 2 hours, 3 hours. That should be before the arbitrator. 1146. My lord will kindly take 1146. My lord, making these imputations against the learned arbitrator is not
I'm
correct.
not making any
Please,
imputation.
Mr. Chaudhary, I did not interject.
He is somebody
Mr.
I
Mr.
respect
Mr.
completely.
Please, I did not interject. My lord kindly comes to 1147 at paragraph 3. He is saying that he was not given an opportunity of being heard. Please, Mr. Chaudhary, I did not interject you. Please maintain civility.
I wasn't.
Please maintain civility. Be that as it may, after pronouncement of the order of refusal of adjournment, Mr. Chaudhary, the learned senior counsel appearing on behalf of the respondent, submits on instruction from his client that in the event the prayer of adjournment is refused, he has been instructed not to argue any further. And he says that he was not heard.
Yes, of course. It was at 1:15 in the afternoon.
My lord,
Joined virtually from court.
please, we are not in a.
Why are you
No,
shouting?
please don't, because let me argue. You argued your case. My lord, the date of the preliminary award is dated 20th of February 2025. My lord, kindly makes a note of this. I'm not even delving into the merits of this case. A well-reasoned award my lord, the earlier minute is just before that. All minutes have been culled out. That's at 1144. Liberty was given to find notes.
Without arguing. This is justice.
He chose not to argue.
Yes. Milord, just see the 3 minutes. 3 minutes. First, Milord, please come to 1024. Volume 8. Just 3 minutes. Final, where evidence is recorded for 1 year. 1024. Volume 8. Annexure MM. In the last sitting, Lordship has seen, Milord, in the last sitting, as the parties wanted further time for settlement, today was the date fixed for further hearing. Today, the respondent has sent an email to this tribunal at 12:03 p.m. stating that he wants 7 weeks further time for effecting settlement. Also, Milord, please note, this is 29th sitting at 1:30 p.m. during lunch hours on a working day. Because, no, yes, we agreed. Now, Milord, see this. Paragraph 2, it appears that this tribunal's mandate is going to expire on 3rd March and this is 20th January. Therefore, this tribunal, therefore, it is not possible to grant further 7 weeks time. This tribunal wants to pass a preliminary award on the question whether in the absence of notice of retirement, it is legally possible for a partner to retire. On this issue, there is evidence taken for 1 year.
He needs 4 witnesses.
Paragraph 3, be that as it may, if the parties in the meantime decide to amicably settle their disputes, tribunal cannot stand in their way. That's all. Then, if paragraph 4, if the parties decide to settle their disputes, they are free to come up with such settlement before this tribunal pronounces on the preliminary point raised during argument. Since today is 20th January, to enable the parties to give further opportunity of settlement, this tribunal has decided not to pronounce any final decision till 10th February 2025. So this is the first day, this is the last day. And then it's kept, my lord, please see 1027. This is, I think, 29 sitting. Now, my lord, please come to 1027. 30th ko thayega. 1118, my lord. Volume 9 is the 30th sitting. The next one. 1114, my lord. It's set out. Your lordship can see it. This is again at 1 p.m. on virtual mode. Yes, these are agreed dates. And at the same time, the parties were settling. Parties were still meeting together. We were under the expectation it would be settled. Now, the race, my lord, for a settlement is against the 29A mandate. My lord, nobody ascribes a little bit of, my lord, malafide also to the procedure. The learned arbitrator is the fairest person possible. But his lordship's, my lord, notion is, I will not allow extension of time. Which is why I will finish.
File the 29 days.
No, I have applied
As
for,
I did.
No, I have applied for adjournments before the learned. Even on the last day, I applied for adjournment.
They are proposing my 29
they are participating in settlement meeting. And then learned arbitrator says, you please submit whatever you can.
Bank was never interested in the settlement.
Of course.
He was never.
Of course interested. Now, learned arbitrator says you submit what you can. What can you submit in this way? 1 year of evidence is taken, and in 1 minute on a virtual mode, what can I submit? I said I can't make any submissions.
After conclusion of hearing, the says the parties are free to
Now, my lord.
29A3, 31st sitting.
I'm sorry, my lord. 30th sitting, my lord. 1144. Look, I must have a chance to argue a matter on merits. I may lose. This is not the chance. I am not saying improper procedure. His lordship, my lord, to be fair to the learned arbitrator, made it very clear to me, I will not extend time and I will make you finish. And on this adjournment request, I will not grant you time. This his lordship made clear for the last 3 months. My lord, it's not that I was taken by surprise. Totally, my lord, fair disclosure by the learned arbitrator. I have nothing to complain. Only one complaint. That I couldn't get a chance to try and convince his lordship on the merits of the case. If I get that chance, I'm happy to go back to the learned arbitrator. As we say, my lord, he is the fairest of them all. See, my lord, I should never, my lord, be understood to mean that the learned arbitrator was unfair. Earlier, my lord, there were joint players made. Last, my lord, when they realized this is about to happen, my lord, please see 1144. It's 5-10 minutes. And on this day also, today. Just let me pray for, my lord.
No, my lord, I seriously. My lord, I just give your lordship 3 days. I just give your lordship No, no, I just give your lordship 3 dates. They can challenge the final award also. My lord, the preliminary award is dated 20th of February 2025. This Monday. But could it be on Tuesday? Yes. Monday I am not here. Could it be on Tuesday?
Yes, yes, yes.
So 3 dates, my lord, if your lordship kind. But my lord will kindly make it clear that there is no stay. There is.
Then he'll pass a final award. Let me pray for the adjournment.
So they are opposing the 29A. They are opposing the 29A.
29A, I don't have a problem.
They are opposing it.
I want to.
They could have asked the arbitrator to recall his order.
How can
As
I?
per-
He has
as
no
per Srei-
power.
What are you saying, Mr. Chaudhary? As per Srei and tough drilling,
No,
power of
no,
recall
no,
is
no.
there with
No.
the arbitrator.
Shri Taftiling was, my lord, from this honorable court. The powers don't, my lord, include
The powers
to
of
recall an award.
not the award, the order. But first of all, it is not maintainable. What is the
My
exceptional
34
circumstances?
will become
What
totally
is the exceptional
infractuous
circumstances?
if final award is passed today. My
2022.
34 will be infractuous.
22. Manoj will
But let
kindly-
us come
kindly-
back on Tuesday as he wants. Just give me 45
2022.
minutes.
Manoj, 2022, 1 SCC 75. If your lordship kindly takes the paragraph 18, last few sentences, just above paragraph 19. Your lordship is aware of this judgment. It is therefore prudent for a judge to not exercise discretion to allow judicial interference beyond the procedure established under the enactment. There is no provision of appeal against the order of 36. This power needs to be exercised in exceptional rarity. This goes even
Then
further.
to-
This goes even
Then
further.
you mean to say that Article 227 will
I am not
be
for a moment
maintainable?
saying that L. Chandra Kumar is very clear about it.
If this is a question your lordship will decide.
Exceptional rarity. Let him show what
So this is exceptional. Man goes to arbitration.
I can, but my lord, what has been our experience, my lord, that
Yes, yes.
my lord fixes it on Tuesday at
Tuesday
any
we'll
time.
come and do it.
Or let it have it on Wednesday because I have a fixed matter before court 16, court 16 on Tuesday. So let it be on Wednesday.
Because whenever your lordship feels.
It can be 12 noon whenever your lordship wants it.
And if it's yes, only problem is, I'll continue. Only problem is, my lord, that Thursday I'm not in Calcutta. If it spills over, let it spill to the last day. I'll come back and do it. That's the only reason. Otherwise, let him choose your lordship's
or Tuesday at 3 o'clock. I'm okay.
আমি রোজ আছি খালি থার্সডেটা নেই
at 2, whatever time, except for the first half, because I might be stuck there. But they mentioned that it got it upgraded. This was filed
You,
3 months back.
he would have taken an award today otherwise, with his
I'm
special.
entitled to.
For the petitioner. Three things, my lord. My learned friend is last occasion. Last occasion, yesterday, my lord, learned friend has relied two judgments. One of a coordinate bench, another is honorable apex court, my lord. Yes.
Yes, it's pending.
Yes, but judgment will not be pronounced. My lord, that's one aspect which with my learned friend, I abide your lordship's judgment. I am second aspect, my lord, which my learned friend yesterday told that the cause of action arose 20 years earlier. They have filed the instant proceeding in 3/10/2023. You know, e-court, my lord, we get. And the amendment came into effect in 2019. Yes. Second issue, my lord, kindly once, my lord, come to the section 5 application which they have preferred, my lord. Page.
Section
Yes.
5 application was rejected by my lord.
No.
Yes, section 5 application was rejected. If your lordship kindly come to the impugned order, page number, last page. Last page means, my lord, first, second, third, fourth paragraph. Sorry, fifth paragraph. Therefore, the petition filed by the claimant for condonation of delay deserves no order being infructuous and is rejected accordingly.
কোথায় বলছেন?
এই তো আপনার impugned order.
Therefore, the petition filed by the claimant for condonation order.
Whatever they have written in the paragraph number 4 is absolutely wrong.
No. He have filed in, I have given the status, my lord, 2023.
My lord,
if my lord kindly sees.
Impugned order itself is very much clear, wherein it has been
kindly
stated,
sees the filing date.
Wherein it has been stated, my lord, 6 months, last page, first, second, third, fourth paragraph. 6 months limitation period was prescribed in section 110A3 of Motor Vehicles Act 1939, and thereafter the earlier act was repealed and Motor Vehicles Act 1988 was introduced, and the Amendment Act of 1994, the limitation clause was omitted with effect from 14/11/1994, and the clause of limitation has been reintroduced by the Amendment Act 2019, and no. Yes, there was no limitation. Maybe. Yes, my lord, Miss my lord. That is. Yes, but my lord, the question is that whether the cause, if the cause of action arose prior to the effect of this reintroduction of Limitation Act, that will be of a retrospective effect or not? That the question that question has also been under the supervision of Honorable Supreme Court. Whether if the accident took place prior to the reintroduction of. Honorable Supreme Court has, my lord, in the 2025. No. Only
The thing is stated. All the cases are same, my lords, on same ground. If your lordship kindly come to page number, para number 5 of the judgment, ICICI Lombard General Insurance versus IIT Navnitha. It is made clear that during pendency of the speed petition, the tribunal or high court shall not dismiss the already, but by limitation. Yes, I have filed the case after 99 amendment. My lord, kindly see. Yes. But my lord, that question is also now, my lord, if your lordship kindly come to the judgment passed by the court, honorable coordinate bench, page 4, paragraph 4, the question which failed for decision before the court is whether an application under section 166 of Motor Vehicle Act could be rejected by the learned court. Yes, my lord, that means the question why we have referred this appeal, why the claimants went to before the Supreme Court, or the sometimes my lord, the insurance company also. That is, the question is that those accidents here.
No, no, no. These are the patch of matters where
my claim and the opposite party's counter claim both allowed. The counter claim exceeds my claim amount to a certain extent. The differential amount is around. We've solved them.
My lord, I am happy for Union of India, my lord. But my lord, due to this election, my lord, they cannot come, my lord. But if you lordship kindly keep it after vacation, then I can take instruction, my lord.
Own election.
My lord, all are central government employee, my lord. They cannot come and give any instruction, my lord. So let it be after.
Your lordship, in that
vacation.
Case, you want it to be after the vacation?
Yes, my lord. I will be grateful so that I can take instruction.
But what about the execution case? It is proceeding.
It is
that's
my stay. It's my section 34. With that, I filed a 36-2. I'll just indicate why I filed a 36-2. It is because, your lordship,
over. No, it has come back to me. There was a certain amount which you owed to him.
Yes, your lordship.
There was another portion which was owed by them to you.
Yes, your lordship.
Instead of setting it off, he had asked you to pay the entire.
Now, your lordship, the termination aspect has been upheld. Now, unless the award is stayed, I cannot participate in tenders because these railway tenders has a clause that once the termination is held to be good, then I cannot participate in those tenders. These are what my instructions are, which is why I was praying for a stay. So even if for a limited period it could be stayed, because I'm told in the first week of June or second week of June, there's a tender which is upcoming and I want to participate. So I'm disabled because of this.
Why do you want the award to be stayed?
Just be stayed because your lordship will kindly just take the operative portion of the award, which starts at page number 34 once. Your lordship will kindly see 61, which is the operative portion.
Page 34.
34, your lordship, is where the award starts, 14th of
Yes.
November 2025.
Page 61.
At 60, your lordship, in fact, the final order starts. The termination of the page number 60, 8.1. The termination of the contract dated so and so between the petitioner and the Southeastern Railways under clause 62 of the general conditions of contract is declared lawful, valid, and binding. Now, the moment the termination is held to be good, I am precluded from participating in.
Why? This is not a penal termination.
This is not penal.
Contractual. That will not affect
no, because your lordship, I could not complete the works. That's why. That is what the finding is. These are what my instructions are, which is why we filed the 36.2. Otherwise, your lordship, for the differential amount.
No, but 36.2 is still pending consideration on the basis of
the differential amount. So the conditional order of stays that I put in the differential amount, there'll be a stay. Although your lordship, I had showcased to your lordship on the last occasion that differential amount and in excess that has already been adjusted by the opposite parties in 2010.
Where is the order, conditional order of stay?
Your lordship, that is the impugned order.
Page?
Your lordship, the impugned order would be in the page number. Your lordship, the certified copy is there. The learned trial court. Your lordship will kindly see internal page 10 of the certified copy.
Certified copy usually should be at the end. There is nothing.
No, your lordship, it is actually wrongly filed. I take responsibility for that. It's in the inceptive portion, right after the synopsis. The certified copy has come up.
That is only website copy.
No, lordship,
we have not filed certified copy.
Lordship, my instructions are we file the certified copy.
They're not stitched with the petition.
I am told it was filed on the 11th of this month. 11th of this month with the department.
Then they might not have incorporated it.
Lordship, we'll take in request the department to look. Internal page 10 of the certified copy. Lordship will kindly just see the differential amount of 1,31,489.
Very well. Your time to deposit this was till 19th of November 2025. I'm extending that time, so the stay will be operational.
Your lordship, then I'll have to put in the money, which is.
I'm not disposing this off because he has prayed for time. Learned advocate Mr. Onuran Shamanto, learned advocate appearing for the opposite party, seeks some time. Full stop. He submits that he has not yet received appropriate instructions from the opposite party. Right?
Yes, I'm grateful.
Paragraph. Mr. Chakravarti, learned advocate appearing for the petitioner, submits that the order of stay passed by the learned executing court, learned 34 court,
the commercial court at Alipur.
Being the commercial court at Alipur in Misarb, within bracket com 09 of 2026, is conditional upon deposit of a sum of rupees 1,31,489. Full stop. It is submitted that such deposit was to be made by November 19, 2025, failing which the stay would stand vacated. Full stop. As has been recorded in the order dated March 25, 2026, this court was prima facie satisfied that the petitioner has been able to make out an arguable case. Full stop. In such view of the matter, there shall be an unconditional stay of the award till the end of July 2026 or until further orders, whichever is earlier. Full stop. In the meantime, comma, list this matter for further consideration as an upgraded motion on June 16, 2026. 16 June.
Let it be on third week of June, my lord, because after vacation, let it be on third week of June. On third week of June, my lord. Any day.
Since Mr. Mr. Samanto requests for listing of the matter in the third week of June, comma, list this matter as an upgraded motion on 22nd June.
I'm grateful, my lord. I'm grateful, my lord.
22nd June, comma, 2026, by which time, comma, the instructions should be forwarded to the learned advocate representing the opposite parties. Full stop. Paragraph. The legality of the order of stay, the validity of the order of stay, conditional stay as granted by the learned commercial court shall be tested during the final hearing.
So grateful to you, Lordship. Your Lordship, the affidavit of service.
Affidavit of service filed in court today is taken on record. Mr. Aruna Samantur namta record kore dibe.
I'm grateful, my lord.
Grateful.
Next.
Lord, I appear for the opposite party number 1 in this.
For the opposite party.
My lord, if your lordship recollects, this is the matter.
Yes, I remember. Yes, sir.
My lord, I had taken your lordship's liberty to place 1 or 2 judgments and 1 or 2 points. My lord. Just a few judgments. My lord, if I just can give your lordship just a gist of what I had. So basically,
a licensee under a licensee seeks to stall the execution case on the basis of an application
and claiming no independent right in the property.
Under a licensee.
Correct.
And the superior licensee is bound by an eviction decree,
which has reached a finality pursuant to the Supreme Court. So now today, what is his case? My lord, I'll show your lordship the paragraph that is indicated in Order 21, Rule 97 application. Ideally, it should have been a 99.
Ground is fraud and suppression, that he has suppressed that he had knowledge. He ought to have come earlier.
One is the knowledge part, the entire knowledge part. Then he also suppresses the orders of the court,
by dint of which he was his inductor was restrained from inducting, and he has been inducted at a time when there was an injunction in operation.
Absolutely, my lord. So, my lord, only one thing, if your lordship judgment my lord, only one thing, one judgment, my lord, that Papaya Shastri judgment.
Fraud.
On suppression mostly.
State of Andhra Pradesh, no?
Yes, my lord. In fact, if your lordship will looks at a recent judgment of 2024, 4 Supreme Court cases, page 432.
We used to cite this 1994 1-1.
Yes. Now, if your lordship takes this judgment, KD Sharma judgment ekhanei to ache. Well, there's a reference to a judgment your lordship will find in paragraph 4. No, 4 na. In paragraph 3.
Yes.
Of KD Sharma versus Steel Authority, which is 2008 12 SCC, page 481. Well, just see that quoted portion, which is para 39 of KD Sharma. The primary objectors highlighted by such and such is kept in mind. An applicant who does not come with candid facts and clean breasts cannot hold a writ of the court with soiled hands. Suppression and concealment of material fact is not an advocacy. It is a jugglery, manipulation, maneuvering, and misrepresentation which has no place in equitable and prerogative jurisdiction. If the applicant does not disclose all the material facts fairly and truly, but states them in a distorted manner and misleads the court has inherent power in order to protect itself and to prevent an abuse of its process to discharge the rule nisi and refuse to proceed further with the examination of the case on merit. If the court does not reject the petition on that ground, the court would be failing in its duty. In fact, such an applicant requires to be dealt with when a contempt of court for abusing the process of court. Then, my lord, kindly take next paragraph. No, my lord, paragraph 6. Na, it was held. Then, my lord, kindly take paragraph 6 once. Actually, I am using a SCC online version. My lord, placitum G. My lord, kindly take placitum G. It is now well settled that a litigant who attempts to pollute the stream of justice or who touches the pure fountain of justice with 10 hands is not entitled to any relief, interim or final. So, my lord, here when we pointed out, my lord, our specific contention is that when we pointed out and the court prima facie came to a conclusion that there has been deliberate fraud and misrepresentation, instead what the court does, blesses the party with an order and protects his possession. So, my lord, my first contention before your lordship is that, my lord, this could not have been done. And since he does not claim any independent right in the property, my lord, he claims his right through the licensee. So once you claim a right through the judgment debtor, your 99 petition in any event is not maintainable. If your lordship will see the language of Order 21, Rule 99, your lordship will find that. And my lord, there is a in fact, my lord, there is a judgment that we've been able to take out, which exactly considers this. This is a Karnataka judgment. Well, if your lordship before that looks at Order 21, Rule 99 once, which is the third party person who's affected by the decree or whose possession is being interfered with, has a right under 99. Can you see the language? Where any person other than the judgment debtor is dispossessed of immovable property by the holder of a decree for the possession of such property, or where such property has been sold in execution of the decree, then, my lord, thereof he may make an application. Now, my lord, kindly read this with 101. 101. All questions, including questions relating to right, title, and interest in the property, arising between the parties to a proceeding on an application under 97 or 99.
Means questions which have not been adjudicated in the suit.
Right. So,
it can't be a re-adjudication, because then res judicata and all these points will go to the wind.
So, you must claim an independent right. If you are claiming a right through the judgment debtor, well, this principle, in fact, well, just one paragraph of a Karnataka notun jeta dila esche ota. Well, kindly, well, take, well, the entire discussion is there. And, my lord, if your lordship kindly takes once paragraph 9.7, which would be at page, which is the if your lordship will see the page numbers are on top. If your lordship will find 9.7 is at page 23.
Yes.
And, my lord, kindly turn to the next page. My lord, the entire discussion of all the judgments so far as 97 to 99 is concerned. My lord, kindly take that before Roman 1, numerical 1, 2, 3, thus, just the sentence, thus I answer point 1 by holding. I'll indicate to your lordship what was point 1. In an application filed under Order 21, Rule 99, the first question that would be required to be determined is whether the applicant is a third party or is claiming under the judgment debtor. Then, my lord, the answer is, if the applicant is claiming under the judgment debtor, the application would have to be dismissed on such a finding. And this considered, if your lordship will see, it considers all the judgments. Yes, well, there is one more judgment where its Supreme Court says that he doesn't even have the right to resist. Well, 2001, 10 SCC 508. Well, kindly consider paragraph 5 and 6. It was urged on behalf of the appellant the subtenants had no independent right, and the High Court committed a grave illegality in allowing the writ petition by directing the executing court to decide the objection of subtenants. We have heard counsel for the respondents, and we find that the argument raised is well substantiated. My lord, deeply obliged. And your lordship has already taken notes. I'm not troubling your lordship that this is nothing, my lord, but a process to circumvent the decree which I have finally obtained after 20 years of litigation.
Yes, sir.
Well, in fact, if your lordship will, but towards admitted occupational charges from 2010, it's a 83,000 square foot, 83,000 square foot of commercial space is in excess of 37 crores. With the all order passed, execution applications pending before this court and before.
Yes. Lord, your lordships have times without number through various judicial precedents held that a court exercising supervisory writ jurisdiction under Article 227 of the Constitution of India cannot act as an appellate court or enter into the plea of the merits of the case. The examination has to be limited to three aspects. One, whether the subordinate court has failed to exercise its jurisdiction. Second, whether it is exceeded to exercise its jurisdiction. And third, whether the impugned order is so perverse that no reasonable person could have arrived at such a conclusion. Mere error in law or on fact recorded in the is not, that is beyond the scope. In the backdrop of this touchstone, your lordship will kindly have the orders impugned ones. The first order is 31st March 2026. By way of the first order, there was a blanket stay on the execution proceedings. On what count? On two counts. One was taking cognizance of my application under Order 21, Rule 97, 98, and 101, and holding that pending any objection insofar as dispossession of the property is concerned, the court is not permitted to dispossess the person who is already in possession of the property. And second, there is an order passed by a competent court of jurisdiction that is an order of status quo. Upon taking cognizance of these two issues, there is an order passed staying the entire execution petition. Now, your lordship will kindly have the modification order that is modified the order dated 31st March 2026, wherein the petitioners have contended that there is collusion and this entire effort has been taken by the opposite parties to stall the proceedings of execution. Your lordship knows, my lord, I'll place Supreme Court judgments in this proposition as well, that any person, the term couched in Order 21 to 97, any person can approach the court executing, saying that, look here, I cannot be dispossessed from this property.
But then, would that mean reopening of the suit on the same issues?
I'll tell your lordship now.
Which needs to be answered, because Order 21, Rule 97 proceedings are in the nature of a suit, which culminate in a decree under 101, which is assailable by way of an appeal.
I'm grateful.
It's not an interim order.
Yes.
Now, therefore, if an issue which has been an issue in a suit or could have been an issue in a suit and has been decided either expressly or by implication, can again be raised in an application under Order 21, Rule 97, has been answered in the negative always.
I'm grateful for what's falling down from your lordship, my lords. First, insofar as what is fallen down from your lordship, first submission is these were inter se disputes between the parties resolved by way of a private mechanism. I am not a party to the resolution.
If you claim through a person who is superior to you in title and his title has been negated by court, you are bound by the decree.
I am grateful, my lord. The question then arises is
If
whether
you're superior landlords, even
whether-
if I treat you as a tenant, here it's a case of a license.
I completely bow down
License.
from what's falling down
If
from the
you
lordship.
being a superior landlord is knocked off by a decree, then the person who claims under you would, by parity of reasoning, will be knocked off.
The question then, the question, my lord, then arises with the greatest of respect is, this is a fact-finding mission that has to be gone into by the
Very well,
executing court, not by the
Not
revisional
that,
court.
it's not that I'll pass a decree here either in his favor or in your favor. But then if I find that there is indeed an illegality or a material irregularity, I can always exercise the
Your lordship will
227
kindly appreciate that the petitioner is inviting your lordship to adjudicate upon the disputes that are already res sub judice
Very well.
before the subordinate court.
Next
Your
point.
lordship will kindly have the objection that was taken. Your lordship will, my lord, kindly have the order dated 2nd April 2026 once, my lord.
Page.
This, my lord, this is not numbered because these are the impugned orders, my lord. This you'll find after 753. Your lordship will first have the impugned order dated 31st March 26. And then your lordship will have thereafter the modified order.
Second April, yes.
Yes.
To the page.
There your lordship will kindly have the internal page 2 of the order dated 2nd April
Yes.
2026. Your lordship will kindly appreciate insofar as maintainability is concerned.
Yes.
What is the plea that is being raised by my by the petitioner? I'm placing paragraph 2. Thus, the learned advocate on behalf of the respondent.
Let us assume that theoretically, technically, it is maintainable.
Yes, my lord.
Would you be entitled to a stay? Let us come to the most basic question.
Yes, my lord. Now, insofar as this issue is
What would
concerned,
be required for a stay? A prima facie case?
the
Balance of convenience?
yes, balance of convenience is required.
Irreparable loss and injury? Which one of these is? All 3 or 4 of them are required.
Yes.
Urgency is one of them. Which one of these is in your favor?
Now, my lord, I'll tell your
To
lordship.
satisfy all 4.
Most definitely, my lord.
Satisfy prima facie?
Yes, prima facie, my lord, your lordship will kindly appreciate that before being dispossessed, it is no one's case that I'm not in possession of the property.
Doesn't matter.
Yes,
That's
I
the
am.
execution.
I am in possession of the property. In order to object to such execution of the property, I've preferred this application. Now, the conundrum that is facing your lordship is that there is an order of injunction that is already operating in my favor, an order of status quo passed by a competent court of jurisdiction in my title suit. That is being contested by the petitioner. Only upon being satisfied.
That they will take. This is not the order of status quo which is under challenge. The order which is under challenge is whether by way of an execution in an execution proceeding, the executing court could have stayed the execution on the basis of this case that has been run by.
I'll tell your lordship, my lord. Then what happens is that this runs contrary to the principles of your judicial committee, my lords.
What is the order that is passed in the suit, Mr. Bose?
My lord, your lordship will kindly have
What is
the order.
that is passed in
The
the suit?
status quo order at page.
In his suit,
Yes,
status quo.
not to
In his suit,
possession.
status quo.
Then if there is an order of status quo operating till such time that you get this vacated,
Yes,
how will you execute
I'm
the
grateful.
decree in respect of the
No, but
property
the
which is under
court,
the status quo order?
but if your lordship will see, the initial order was not passed based because of the status quo.
Very well. If subsequently also the court comes to the conclusion, then also you will not be able to execute the decree insofar as the order of status quo.
Correct,
governing the
absolutely,
property is
absolutely.
concerned.
But today, if the court said that I will consider your interim prayer subject to status quo, I would have understood. But there is an independent finding of the bench that regardless of his suit, now if
that we can always set aside. But in so far as the status quo is concerned, that cannot be disturbed.
no, it cannot,
by
it
the
cannot.
executive
I bow down. I cannot. I don't say it can.
forum against the other.
Absolutely, absolutely.
Possession,
But
then
this is also not our contention. Our contention is that we've already
evidently it could not have been granted. is your
absolutely. So if the court had said, since there is a status quo order in a civil suit, the execution so far as this cannot be proceeded, subject to the, I would have understood. But there is a
status quo order is in respect of the same property in respect of which stay has been granted.
only his portion.
So that is what the order is now. The order impugned upon being modified.
Correct.
Is restricted only to that.
Yes. And so what he gets, he's got a stay on my execution to that. So he's got now 2 orders. He has a status quo in respect of his possession.
I'll clarify this, that the execution case will proceed subject to the status quo order, which is there in the.
Very well, very well, very well. And but this order has to be vacated. Because
This will go.
Yes,
it will
yes,
modify,
yes,
it can
yes.
modified to the extent that the
Yes.
status quo order, which is there,
Right.
that will be in operation. And if that goes, the execution will.
Your Lordship
Yes.
will kindly appreciate, my lord, that upon taking cognizance of the status quo order, has this stay been granted? Your Lordship will kindly have the impugned order date 31st March
Very well. I'll
2026.
give my reasons for this, because
They've
I'm
taken
stating this so that we can cut short. We have other matters also.
Hmm.
I'll fix another day. I'll pass my orders then.
In
Because
both
today,
the
if I
orders, the
start
status
passing
quo.
order, it'll take me at least half an hour to deal with all these points.
Right.
My lord, in both the orders, the status quo order has been taken cognizance of.
Hmm.
Pursuant whereto this order has been passed.
You
It is a
want
matter
to,
of record.
add anything to what?
My lord, just
the
one
ultimate
judgment.
conclusion which I have said, as of now, that is going to be.
My lord, then it will be subject to the order of status quo naturally.
Has to be.
And
Has to be.
my lord, in that.
Has to.
That
Has
nobody
to.
can say,
Has to.
because the
Nobody.
status
And-
quo order cannot be undone by the executing court.
And
It's
my
subject
lord,
to-
also my order 21 rule 97, my opportunity to press that before the
that,
court should not
that
be.
I'm not going to reject and
Yes.
decide your order 27 here.
Let that be
Order 21
decided on
rule
merits.
97
Let the execution court find a.
লিখে নিন।
Yes, yes, yes. Of course.
Insofar as I am concerned, Lord, I had already presented to your Lordship.
Your 47 is pending. You remind me when I pass my orders on the next day. I'll pass it in court only, so that a lot of facts are there. Heard Mr. Bose, the learned senior advocate, appearing for the petitioner, and Mr. Raichodhuri,
Ganeriwala.
Mr. Ganeriwal, appearing for the opposite party number 1. And you are, and Mr. Haq, appearing for the opposite party number 2. List this matter for further consideration on May 19th, Tuesday,
Tuesday. Very well.
Grateful, my lord.
2020.
Great.
Can we have it post lunch? Because then I'll because dictating in open court is easier always.
My lord.
Dictating in open court is easier always than
Yes,
carrying
yes.
it back
Certainly.
home.
Certainly.
May it please your lordship. ERT matter, my lord, I have come up against the order, my lord, by which, my lord, a section 14 application has been allowed. I am conscious of the fact that the law is overwhelmingly against me. But please have a look at the order once. I'll not trouble your lordship too much. I believe that there is a little bit of a gap through which I can come in. If not, otherwise, my lord, the law is overwhelmingly against me that I need to go to an appeal.
Mr. Banerjee, please go before the DRAT. Challenging the DRT's order.
Yes, I'll tell you, lordship, why, my lord, I'm coming here. Just, my lord, kindly give me 2 minutes. I'll not. We are all aware, my lord, of the position of law. Settled position. I'll not try and disturb. They are saying they are deprecating. They are saying you should not.
Absolutely, absolutely. It has no longer remained a judicial restraint. It is more sort of a discipline that we are going to follow now. It's no longer discretion in that sense, because in these cases, Supreme Court now regularly. High courts are cautioned not to do that. There are repeated judgments. So I don't think I should.
But there's only one thing, Lord, which I'll just submit before your lordship without showing lordship the order. My lord, why I have come up before your lordship here on this? I was aware of the law. I will not go into L. Chandra Kumar and all that, Lord.
That's
despite all that, consider and say. Only thing is, Lord, section 14, Lord, order has to be passed upon satisfaction of the principles of the proviso, or existence of the factors of the proviso. That is present in an affidavit along with the section 14 application. I am the aggrieved borrower. I went up in 17 saying that they were not looked into. I said that they should be disclosed. The bank did not disclose them. No record was also before the tribunal. Tribunal said, no, whatever he has done is proper. Is that appealable? Only this.
Yes, because ultimately it is the tribunal's order. It is the tribunal's order.
If I can show, subject to what falls in my lordship, if I can show that this order is a nullity under the law held by the Supreme Court, then, my lord, whether your lordship will consider.
Even then, all these points can definitely be taken before the DRAT. You go before the DRAT.
Natural justice is also there, Lord.
That's there, but Mr.
My lord, I'll tell you, lordship. Kindly give me a second's time, Lord, to just act with this. This is so shockingly perverse.
Lord, all of them.
Let us say, Lord, my lords are sitting, Lord, in revision jurisdiction over an order. That order is not before your lordship. None of us produces that order. I tell the other side to produce the order. He doesn't produce the order. It's an order made by his client. My lord has no opportunity to look to the order. My lord only looks to one thing, that according to the law laid down, the action is ministerial, and therefore all that is required is subjective satisfaction of the magistrate concerned. Saying that,
Mr. Banerjee, touch the DRAT and come. I'll be able to entertain it better. Just touch the DRAT and come.
But then, Lord, there's this pre-deposit that stands in the way, Lord. We'll be undone by that pre-deposit. Had there been an adjudication, my Lord, had there been an adjudication worth its name, my Lord?
Still, Mr.
There's also violation of natural justice that day, that particular. It's the date fixed the final hearing.
Nothing. Final hearing, let them go. Chalo, call karo, next call.
Why don't you not rise?
Oh, yes. Come back. Come back.
এই জন্য আমার নেতা সব লাগছে
আজকালকার তো তোর বই আনে না, তো কপি আনে।
বই সাথে
না, আজকাল তো বই আনে না, কপি আনে।
Mr. Basu, how long will you take?
Minimum half an hour.
Problem is the vacation, because there are a lot of urgent motions waiting. Can we have it immediately after the vacation, Mr. Bhattacharya?
We have been suffering like anything.
That's there. It's almost hard. We can
Without-
fix it immediately.
But any matter is there in Calcutta High Court without suffering has come to court.
No, no, that's a different
Anybody-
thing. It's a degree of suffering. Well, I have paid money and I'm suffering interest.
If a refund is directed, you will get it with interest only. So it's not a problem. Problem is the time, because there are others who will be kept waiting.
I think no, he will not take half an hour. He's threatening us with
No,
half
no,
an
no,
hour.
no, no, no. Because my lord was initially against me, so I have to convince my lord. Try to convince. my
Anyway,
lord.
I leave it to the court's convenience. Kindly visualize my degree of sufferings.
You are already
Can we
suffered
have it
another
on the
for-
last day?
another
Then we'll not have. I'll close the hearing on the last day.
Last date, yes.
Huh?
22nd.
Yes, that's better.
No, 22nd, my lord.
Why?
22nd.
Because that will be easier for everybody. The court will also be a little light.
কবে যাচ্ছে 21 টাকা?
22.
এই 22 সন্ধ্যেবেলা যাচ্ছে তো।
Last day, my lord is from here. Last day, my lord is
So
fixing
let it
time.
be 21st. 21st.
21st, I have a lot of fixed
Same
matters.
problem.
12টায়।
21st এ 12টা রাখলে তো আজকেও 12টায় শুনতে পাবে।
সেই একই ব্যাপার। Can you keep it any day just after vacation?
22nd first half.
22nd first yes.
22nd ছুটি তো।
না না।
22nd is the last date, my lord.
Yes, first half.
My lord is forgetting those days.
First
No
half.
court will sit after 11.
Before 11.
You'll take half an hour. Not be able to go.
You'll take half an hour.
Last day, my lord.
10:30 to 11.
Can you don't
We'll
compel
finish
me
it
to
off.
come on last day?
Why?
Something. Food will not be there to do any matter.
This becomes problematic and embarrassing for
Accepting
the
last
court
day,
also.
my lord,
I have
anything
fixed it today.
But the problem is
no problem.
the problem is that with the change of determination, then again the matter will go out.
This is assignment.
Assigned matter. It will not go out.
Assign hard in part, make it hard in part, no problem. Keep it on the very
Assigned what?
Assigned matter.
the very fast reopening day, can you keep
It is assigned, so it won't go.
Yes, me too.
রিওপেনিং ডে তারপর আবার তুমি শোক মিছিল করবে তোমার তো কায়দা
কিসের শোক?
তুমি তো শোক মিছিল চালু করে দিয়েছো না
What to do?
Reopening day, I have no problem. Won't be problem.
Reopening day?
Where is my reopening date?
Reopening day?
আমার কোন আপত্তি নেই।
হ্যাঁ কেন
জুডিশিয়াল আজকাল আর হয়।
কি আছে এটা হয়ে যাবে ওরা বলবে রিওপেনিং তো থাক ইয়েস লেট ইট বি রিওপেনিং ডেট লেট আস ফিনিশ ইট
Reopening day, you have problems.
No, he is looking at me. Those days has gone. My jurisdiction gone.
Very well. Tuesday, next day, 9th.
No problem. I have no problem. Anytime after vacation, no problem.
9th is a problem also.
but lordship cannot accommodate everybody let it be a
And
fixed
whenever
time
my lord asks the council, that is the problem. Fix a date.
let it be on 8th no difficulty
8th may be monthly list.
কিছু রেজুলেশন হয় না।
এই
আজকাল আর হয় না।
রেজলিউশন হয়তো সকালে আর কিছু হচ্ছে না আমি মরছি না তুমি মরছো চিন্তা নেই
9th will
9th very well 9th at
9th at 3
ঠিক আছে
3 p.m. লিখে নিন। Mr. Basu, please serve a notice on the state you don't know now who is appearing. You can serve the DSGs.
DSG মানে
Yes,
state.
yes. Serve the two DSGs. They can arrange at least the representation of the state on the next day.
We are coming on the reopening. In the meantime, I think somebody will be.
But still, a notice on them will keep them on.
No, if the GP and is appointed in the meantime, you can serve the GP's office.
I'll make provision for both.
Yes,
Please,
yes.
It's only a question of service of notice because then we'll have a complete hearing. List this matter
Yeah, the special
for
order.
further consideration on June 9, 2026 at 3 p.m. Full stop. Together with ওই next WP number যেটা আছে চলো 151 আচ্ছা আর ওই 151 এ একটা অর্ডার দিয়ে দিন নেক্সট WP যেটা আছে তাতে অর্ডার দিয়ে দিন the petitioner shall serve a notice on the respondent state authorities as well as on the on Mr. Dheeraj Trivedi, learned Deputy Solicitor General of India, or Mr. Rajdeep Majumdar.
Or if in the meantime, the panel is
I have provided for all. So you can serve.
Yes, yes, will serve. I hope before that it will be prepared, the panel will be prepared.
A list this matter on May 10, May 9, 2026 at 3 p.m. as already directed in WP ওইটাতে আগেরটা ঠিক আছে সার্ভিস এইটাতে দেবেন ওইটাতে সার্ভিসের দরকার নেই কারণ ওকে মানে স্টেট পার্টি নেই
হ্যাঁ আমাদের হবে
Initially, division bench said, I am senior, division bench. No, who is there? Justice Samba Sarkar. then he pushed me, go. Just to help.
Lord, in item number 8, my lord, I am appearing for the petitioner, my lord. My lord, a very, my lord, simple case, my lord. My lord, I was the petitioner, my lord, before I was a plaintiff before the learned trial court, my lord. I filed a suit for ejectment suit, my lord, which was pending, my lord. It was, my lord, I filed the suit, my lord, on 2019, my lord, September 2019. In 2022, my lord, the defendant was set ex parte, even though he initially appeared. My lord, finally, my lord, I obtained an ex parte judgment and decree on 7th of November, my lord, 2022. Now, my lord, on 16th of December 2022, my lord, the defendant comes and files an application under Order 9, Rule 13, my lord, for setting aside of the ex parte degree. Evidently, my lord, barred by limitation because beyond the 30-day period. And the fact that the defendant has received no summons is an admitted fact. He has himself admitted. However, without considering that question of limitation, the trial court proceeds to allow that application, my lord, on merits. But I'm on that.
Order 9 Rule 13.
Pardon, my lord?
Order 9 Rule 13 has
Order
been...
9 Rule 13 has been allowed, my lord, by the learned trial court, without considering the question of limitation, my lord. I'm on that point.
It was filed beyond 30 days.
Beyond 30 days, my lord. 7th of...
No explanation for delay.
No explanation, no pleadings, nothing. Only just a cursory pleading that there is no delay if any be condoned.
Suit was for eviction of a tenant.
Eviction of a tenant, my lord.
This revisional application is directed against Next.
But this is my service note. Blood eviction suit, I am the dependent by the order impugned, blood my blood the examination of the DW was closed and the matter has been fixed for argument. Blood the order number 24.
Yes. What was the CO 4106 of
Blood the CO that was filed by my client, blood an application under section 151 was filed there, seeking blood the direction for repairing of the shoot property that was rejected, and that is why this application was filed, and application the CO is still pending and appearing before your lordship's list. I'm
Rejected with cost not put in. Then will not, as a ground will not, this was will not also closed. Now, will not, two things will not, he has to will not file show cause will not, why will not, this should not be directly will not challenging the order in civil division will not, then lordship has to will not go into that factual aspect will not, why he could not will not.
Yes, if you can agree, I can impose costs and allow the
That has already been done by the land. There is not for non-compliance, this has been done. Why non-compliance will not, he has to show that.
Where is the earlier order?
Impugned order, blood order number 20.
No, not the impugned order. He says earlier cost was imposed.
Lord, that is order number 20, dated 11th September 2025.
You have a copy? Because only 23 for are annexed.
ওই রিভিশনটা আনিয়ে নি লিস্টে।
হ্যাঁ রয়েছে তো।
Yes, sir. What about this order?
This order
stays in your face. The order is a follow-up order. You have not annexed this order.
But whatever the situation, blood, kindly give me 1 day's time. I shall.
Not 1 day, but what about this order? You have failed to comply with the order directing you to pay costs. The matter was adjourned upon noting your conduct that you are present in court. You still
argumenting.
You have not disclosed this order also. What is the suit for?
Eviction suit.
UG. That's why we not filed.
Where is the property?
But it will not page 14. Schedule is at page 14. Sambaya.
এটা দেখুন বলা আছে তো।
এটা হচ্ছে ওইটা consequence of this.
Lord, we have disclosed this in the petition. Lord, the 151 petition was disposed of. Lord, that we disclosed there.
No, that order you have not annexed.
No, order I did not annex. But
That order was required because this order of 16th April 2026 that you have challenged is a follow-up order. It is only a follow-up order.
Lord, I shall comply with every direction of the learned trial court. Kindly give me a 1 day's time, Lord. Monday is the date fixed.
Kindly see, that was their undertaking. Lord, kindly see, Lord, their undertaking which is recorded. It's nothing to do on my part. Kindly see,
Lord, this order was challenged. Lord, the order number 20, which my learned friend is referring, this is under challenge in the previous civil division that is appearing before your lordships. And showing that order, Lord, kindly see this my brief. So this is appearing in the my lord list. Lord, and showing the blood, showing the pendency of this matter, I pray for an adjournment there.
And
What has
that
happened to this revisional
Lord,
application?
still appearing before your lordship's lord.
That both
এটা এর আগে ফাইল হয়ে গেছে
সেটা
দেখে বলে দিচ্ছি
order is of September.
হ্যাঁ আমি দেখে বলে দিচ্ছি
Order is of 11 September.
Lord, I have challenged this order.
This 16th April
Ah,
2026.
It was filed on
records a pending CO 4106. Is it that 4106?
Yes, Lord. This is
So it is the earlier order which is under challenge.
4106, Lord.
329 of monthly. Item
Yes.
329 of the monthly list, Lord.
When is the next date?
Tomorrow.
Monday, Lord.
Tomorrow. Argument.
Tomorrow, na 16th.
Kalke.
16th. Oh, sir, Kalke 16th. Yes, Lord. Tomorrow is the day. And Lord,
Then take this on. You don't have instructions there.
We are coming to know whether this has been filed, whether no copy given, whether nothing.
No,
intimated.
that was disclosed in the trial court, Lord, by filing
a ground to challenge that order.
Lord, this order, previous order.
Yes.
Lord, the suit property is very much dilapidated in condition.
That is different. The order says something else. The order says that the suit was already on the PH board. You were given opportunity to adduce evidence, and your application for adjournment was allowed.
Their conduct is recorded in the second page, without the last 3 paragraphs. It was not a case that
it says that you are supposed to file. You are supposed to put in costs.
yes, and I do not know why they have challenged this order. This is
Please
in
serve
their
a copy
favor.
on the Mr. Bhattacharya. Can you take adjournment tomorrow? Then we can have it on Monday, both the applications.
Yes, Millard, kindly appreciate, Millard. I definitely, Millard, this I do not find any reason, Millard, to challenge Millard for their challenge, Millard, to the 11th September order. If your Lordship kindly sees the last part of the order, it was for their benefit. Kindly see, it is made clear only after making the payment of the cost by the defendant by depositing the same to the Secretary ELSA Kolkata and file a receipt from the next day. Such filing of receipt will entail the defendant to adduce DW on the next date as a last chance. Therefore, on filing of the court allowed their DW. They did not deposit the cost. They took a chance. Again, I do not know why they have challenged this. This was in their favor.
Costs.
Lord, the cost part only. Cost part, Lord, I shall pay only this to that extent. I shall pay before your Lordship to that extent regarding the imposition of the cost in the previous CO.
Then, Millard, if they are ready tomorrow let the DW be done by the.
Tomorrow, Lord, I have to prepare the evidence. Instead of tomorrow, Monday, kindly keep it Monday.
Order is of 11th September 2025.
That is under challenge, Lord.
That is under challenge for November.
Mr. Bhattacharya, take an adjournment tomorrow. I am keeping it on Monday. I'll dispose of, fix one day, finish it off. I'll lessen the costs. Costs will be there, but I will lessen the costs.
A copy may be given.
Yes, please serve a copy. This revisional application assails an order dated April 16, 2026, passed by the learned judge, bench-10 X, City Civil Court, Calcutta, in title suit number 1027 of 2023, whereby the petitioner's request for adjournment is rejected and the case has been fixed for argument. Full stop.
Lord, I am online now.
Yes. Mr. Chatterjee and Mr. Mukherjee.
My lord.
Can you both agree to a structured or a phased transition from a complete, I mean, instead of a complete day-night to a portion of the period only day and a portion day-night? So that the child is also.
But I will
acclimatized.
rather agree to Lord what falls from your lord.
Child will also be acclimatized with the atmosphere in the father's place, and then it may not be a sudden change for the child.
He was
Milord,
there,
keeps
but
it,
nevertheless,
Milord, he keeps it at 2. I'll take instructions and come back.
Very well, because that
I'm ready and willing, Lord. I absolutely bow down to what your lordship says, Lord.
Milord, they
But
would.
if the child was
Even
here
we
in the
would.
father's place till
Even we would.
2024.
But gives me a little bit of time. I'll just
very
talk
well,
to
very
the
well.
child and
Because
come
I
back to
would
your
also
lordship.
not like in the interregnum. I have also gone through the papers. Uh, there may be a problem, Mr. Mukherjee, because of the. I'll indicate the pages. The sudden change. Suppose something bad happens
Then
to
what
the health.
happens?
But the mother will be here.
Even
So,
then,
Lord, the
Mr.
mother will be here, and mother may
we
be
have
residing,
seen a ray of
Lord,
hope.
somewhere nearby. Lord, they have a house here.
We have seen a ray of hope.
Lordship.
He is progressing. He is developing.
Lordship.
Now, if we offer some more time to him, maybe he'll come out of this
But
completely.
if a child can travel the world, Lord, your lordship has seen, Lord, the travel, Lord, the program. But there, Lord, the child has to go alone.
Milord, I
For
hope
the
and pray
child to
the mother
stay
is
with the father,
traveling
Lord, I
every
don't know
time
why,
with
Lord,
him. The mother is traveling with him wherever he travels. Number one. Number two, Milord, is that this unfounded, sudden, Milord, thing of since he's traveling, that's why he comes in. This is an ego battle. Do not,
It's
Milord,
never an
adhere
ego
to
battle,
that.
Lord. These are
It's
the
an ego
practical
battle.
things that
If
happen.
that was so, Milord, he would have been with the child when the orders were given that you stay with the child. He
Who
didn't.
is taking care of the this psychological aspect of the child?
Me, completely
Because
mother.
the child,
So in Calcutta, who will be
Lord,
taking
prior to
Nobody
going,
can.
no,
just a minute.
up to 2024, Lord, the doctors who are based in Calcutta, because Lord, the mother and the children were staying at the same house. So, Lord, he was treated and he was going.
Not at all. No. Milord, with a
Lord,
lot of respect to my learned senior friend, Milord, he's probably not instructed properly. From December 23, entire, Milord, when he was actually ill, everything was taken care of by the mother at Bangalore.
Because the mother took the
Chennai
child
and
to Bangalore. That's the
Has to
reason.
be. He
Prior
was.
to
He
that,
had
Lord, they were
nothing to
staying
do
together.
with the ailment.
My Lord's question was that, Lord,
He
whether he
didn't
was
even
treated
bother
here
to
properly
ask
or not,
how
to which,
he
Lord, my
is.
answer
He
is
didn't
yes.
even bother to ask how he is. So your lordship wants to, Milord, find out a way. We will definitely, Milord, find that
Because
out.
that would ease. Because
I understand,
Lord,
Milord.
I absolutely, Milord, bow down to what your lordship
I
says. A
understand,
phased
Milord.
manner is
Milord,
not a
if your
good
lordship
introduction.
would be, Milord, would be just a little bit, Milord. If your lordship looks at 235 once, have a look at that, volume 2.
And Lord, for the doctors and the medical treatment, whatever, Lord, that is continuing, the mother will hand over, Lord, the prescription. I will continue.
It's not that easy, Milord. It's not that easy.
Yes,
This
certainly
is
it
not
is
a.
that
This
easy.
is not a like a
Father
typhoid
can
thing,
treat, the
Milord.
father
Like
can
that do.
equally treat also.
The father, he hasn't done it all this while, so he let him not
That
show.
doesn't
Milord.
mean that, Lord, up to
Have a
13
look
years
at
he was not
235.
treated.
Yes,
235. Have
Yes.
a look at the second paragraph, rather the first paragraph. I
Yes.
have known Manan since he was 2.5 years old. Lordship kindly got that, Milord?
Yes.
And have had the privilege of being part of his care and growth over the years after a thorough assessment at Apollo Children's Hospital, Chennai, in December 2023. Under Radhika such and such, he has been under the care of a team of specialists supporting him such and such from Apollo Chennai and in Bangalore, Dr. Amit Chen from New Delhi. Alongside his medical care, Manan has been receiving counseling from Yogini Singh in Chennai and currently with Dr. Kasturi Chetla in Bengaluru, as recommended by Dr. Amit Sen. He also participated in such and such program conducted by Dr. such and such. All of these interventions have been contributed positively to his journey. So from December 2023, Milord, everything has been taken care of by the mother. The father was nowhere near. From Chennai and Bangalore. And everything is done from Chennai and Bangalore and Delhi, my lord. He had no interest. My lord, he had an order of visitation. He did not bother to, my lord, accept it. Suddenly today, my lord, just for the sake of ego, he wants to, my lord, get this order from your lordship. We acceded to that. We said, please have your access. And now, my lord, this bargaining thing comes in that we have to give him for the night. Even then, my lord, whatever's fallen from your lordship, my lord, we will come and tell your lordship what the child feels. I'll talk to the child in the interact now. Suddenly, my lord, this is a very specialized problem. This is not like a typhoid or a jaundice that things can be, my lord, administered timely. There
The
needs
things
a
are
lot
blown
of
out of
more.
proportion, my lord, for the
Things
purpose
are
of
blown, my
denying, my
lord.
lord, the
This is the
visitation
problem.
right.
He
The
has
child can come and stay with me during the
attributed
day.
nothing to the child's health,
But what is
and
being blown
suddenly,
out
my
of
lord, now it's
proportion
blown
here
out
is,
of
my lord, about the
proportion.
medical
Take
condition.
this remarks adversely against him, in my respectful submission. Father agrees before the child, then the lawyers come up in the court and say, no, I can't. This is unfair.
We have never
Extremely
agreed, my lord.
unfair.
We have
Milord,
never
they
agreed.
have agreed. Milord talks to the
I was
child,
also
he
there.
will tell your lordship.
We'll not go into that, Mr. Chatterjee, because that
Very
I
well.
have no means. I have no means to assess that.
That's why I
I'll
say,
have
Milord,
to
talk
go-
to the child, your lordship will find out.
I'll have to go by whatever is there.
Yes,
because
Milord, I bow down to that. Milord,
talking
let
also
me-
on video will not be very fruitful now,
Very
because
well, very well.
Mr.
Milord, I completely, Milord, I bow down. Milord, I bow down to your lordship.
I
Gives
could
me
have
a little
interviewed,
bit of...
but then video calling and interviewing will serve no purpose actually.
Gives me a little bit of time. I will come back at 2 and tell your lordship. I'll just finish this and come back. I'll talk to the child in the meantime.
Very good. Let us see if we can serve this.
Find out a way.
Otherwise,
Yes, Lord.
Lordship, your lordship.
Great,
But, Lord,
Lord.
kindly take it from us, Lord. We are, Lord, agreeable to, Lord, the proposal about, Lord, the gradual, Lord, the shifting. Lord,
Yesterday,
fell
Milord,
from
they
your
were
lordship?
not agreeable to anything. Now it has fallen from your
Lord,
lordship. They are
I'm
agreeable. Very
also,
well.
Lord,
Fine.
concerned about the
Fine.
child, and that is,
Yes,
Lord, my
I'm sure you
positive
are.
step of the father.
Primary concern.
That is
Mr.
a positive step of the
Because
father.
even if
Mr. Mukherjee is
even
more
if-
concerned Milord, than
I
his
think,
client.
Lord, the mother should also be, Lord, reasonable in that
even
respect.
if
Milord, I
one of
don't
the-
think
one
a
of the
mother is
parents has to
unreasonable ever.
sacrifice his or her wish for the purpose of betterment of, if there is even the slightest question that is there that can be raised as regards the child's health, whether mental or physical or psychological, then also the wishes of the parent should be sub judice. I mean,
Subdued or
subjected.
Subjugated to the well-being of the child.
Absolutely.
But Lord, the
Absolutely.
question here is, Lord, about, Lord, what is being projected about the condition of the child.
It's all on record, Milord. There is no
To
projection.
that, my Lord, the
It's all
submission
on
is,
record.
Lord, if the child is
A
proposed to,
Milord,
Lord,
a
travel the
father who
world,
hasn't even taken
and
care
Lord,
of
in
the
that
child
respect,
shouldn't
Lord, for
open
the
his
5
mouth
days or the
much.
10 days, Lord,
But the
staying with the father.
Traveling is not unsupervised, Mr. Mukherjee. The traveling is under
Lord, I'll
supervision.
give your lordship, Lord, they have, Lord, the travel plans, Lord, in the opposition that they have given, Lord. Your lordship will kindly see, Lord,
Everywhere the
how
mother
they have
went with
proposed
him.
that.
Everywhere the mother went with him.
If it is supervised, then in that case it's the same thing.
But I am
Because
there
he
to
has
supervise
been,
always.
The problem, Mr. Mukherjee, is that he has been in a particular kind of atmosphere in a certain way till a certain period
See
of
the
time.
younger child's, Lord, the proposer, Lord, for travel. See the younger child. He is unsupervised.
No problem with the younger
He is unsupervised.
He's a
Milord, the
special-
younger child doesn't have ADHD.
Right. He's a special child who needs a
Younger
special
child is 11 years after all.
special treatment, who needs a special treatment, whatever it is, either medically or socially.
Now
or
he is not being treated. He is only, Lord, there is, Lord, only, Lord, a
I don't think
visit
Mr.
to
Mukherjee is
check
correct
the,
there.
Lord, the condition.
No, he's not correct
They
there.
have relied upon, Lord, the document which I yesterday read, and Mr. Chatterjee also read today, 235. Your lordship has seen that, Lord, the second last
Yes,
paragraph.
he says that yes, there are certain recommendations, but it is not that he is absolutely without any medication or without
The
any rehab.
medication can be administered by the father too.
No, there is something else also, Mr. Mukherjee, because if you see,
Of course.
the well-being of the child has to be of the
Paramount interest.
True, Lord, but how your lordship considers, Lord, the well-being, Lord, that is not the real question. Lord, staying with the father, if it, Lord, does not inure to the well-being, Lord, that is not
Mr. Mukherjee,
a real social question that comes.
I'm not for once saying that child will not stay with the father. The question is, if sudden change could
No,
uh,
I
Can trigger,
don't think that it
can
is not a
trigger.
sudden change. He was
Trigger
here
something.
during the winter vacation. He was
But
there.
that was also during the day only.
That was, bro, that is one
Only during
first
the
part of
day.
gradual,
12 to
Lord,
6.
transition. First part of the gradual transition had happened, Lord,
Then
in
there is
December,
again a gap.
January.
Then there is again a gap, Mr. Mukherjee, which is why the regular visitations, if they continue for some time and then we gradually proceed.
Yes.
Day long, then again tonight. Now the time is too short for us to experiment at this moment. Now, if there is a medical counselor or a psychologist who can assist, I don't know whether we can have it here and whether it will at all work in this short span.
Milord, gives me time till 2 o'clock. I'll come back. Milord, gives me
But
time
if
till
we
2
can
o'clock.
have this, if we can have this amicably for a phased, in a phased manner, then in that case, a lot of problems will be solved and the child will also feel safer.
Lord,
Because
I
I've
bow down to
completely
what your
understood
lordship has
what your lordship has
suggested.
said.
I have to
Gives
go by
me
the
time till
papers.
2. I will try and
I bow down to
get
what
it
your
done.
lordship has
I
suggested.
will try and get it.
But
by
it is
the
now
papers.
Mr. Chatterjee's turn to come up with Lord, a solution.
But if
I have come up
But
with
if
a
he is sticking
solution
on the fact, Lord, that there
before,
will be a
and
day
I will also
visitation,
come up now.
but I will say, Lord, that I will not concede.
Milord, I assure your lordship, I'm not going to take this
I want, Lord,
as
certain,
an
Lord,
adversarial
meaningful
litigation.
visitation during the night too, where I can spend some time with my child, whatever, Lord, the time is.
He wants to spend more time at night. I don't know why he doesn't want to take the entire day, and when he's sleeping, he sleeps with the mother. I don't know what special thing he's going to do during the night. This is a little
But he
ridiculous
used
in
to
my
go to
respectful
club
submission.
when he was here. He's
It's
a
little
member of Lord,
ridiculous in my respectful submission.
most
He
premium
has it
clubs
from
in
12
Calcutta.
o'clock to 10
He
o'clock,
used to
but he
go
wants
play
it from,
Lord,
more
tennis.
importantly, what we are
He used to
not
with father. He used to
comfortable
go
with. He
play
wants that
golf with the
only.
father up to 2023 Lord, December. Lord, so he has an entire lot of friend circle here. He goes to the club. He's a 15-year-old boy. So, Lord, if he is with the father during the evenings, Lord, I can take him to all this, Lord, the places where
Nobody
he
is
can, Lord,
stopping him from the evenings. Evenings he can be with the
and Lord, in
father.
the night, as your lordship knows, we can have
He's not
dinner
going to take
together
to the friends
with
during the
Lord, the
night.
grandparents. Lord, there is a fostering of relationship on that.
And during the night
Lord,
when all of them
so
sleep.
far as it, Lord, that until unless, Lord, there is some gradual, I bow down to your lordship that, well, a sudden change might be an impact. But, Lord, for a phased manner, well, I can do it, Lord, during the daytime for the
Milord,
time
may I
being that
come
your
back
lordship
at 2
suggests.
o'clock, Milord, and tell your lordship, Milord, I've understood what has fallen from your lordship and what's going through Mr. Mukherjee's mind. I'll take instruction from the child itself and tell your lordship what's happening.
But the child, Lord, it is again, Lord, what I have argued last day. But if the child can speak of its own, Lord, wishes, Lord, then there's no necessity for the
16-year-old child
courts to,
can.
Lord, spend so much of time on
We are all
dwell on
thinking
this.
about
Mr.
his
Banerjee,
comfort.
he's not a toddler. He's
15 years.
He's a mature
15
minor.
years, yes.
To be he's a mature minor in that sense.
He takes his own decisions.
He may because he has his podcasts and all these things. So that means he has,
Lord, I can show your lordship, Lord,
has his independent decision-making faculties.
Yes, but the question here is, Lord, whether his independent decision is being influenced by the mother, Lord,
For
to
a
act otherwise.
16-year-old, Mr.
For a
Mukherjee has dealt
podcast
with a
to happen,
16-year-old. He
Lord,
knows.
the podcast can be done anywhere. It can be recorded.
Yes.
And for 10 days, that is not the
example.
issue.
That was just an example.
I understand. I understand.
Intelligentsia question.
Lord, the question here is all about, Lord, that whether the comfort level of the child will be there, Lord, for this brief 6 days, 7 days or not.
That is most important.
So, Lord,
that is the only thing, because
so
parental
anything,
rights,
Lord, that
yes,
is the child
definitely they are
wants,
there.
Lord.
But once the child is a special case, then the parental rights will have to be subjected to
He
these
is not,
special
Lord, a
cases.
special child, Lord, in my respectful submission. But
the
he
child
might
may
be
not be
having
special,
some, Lord, problem.
but he has a situation which makes him amenable to certain special considerations.
Milord, kindly allow me. I absolutely bow down, and what has fallen from your lordship gives me, Milord, time till 2 o'clock. I'll come back and tell your lordship what's happening.
Very well. At 2 o'clock, I have a fixed matter.
Just after that,
if we can get into some arrangement, at least, then in that case we can proceed forward, because 2:30 I have a division.
Lord, I tell your lordship,
Milord,
here
at
is now, Lord, we
2:25
are
I'll be before
agreeable
your
to
lordship.
what comes from your
2:25 I'll
lordship.
before your lordship and
Come at
inform
2
your lordship.
You come
I'll
at
do
two
that.
only. You
I'll
come
do
at
that.
two only.
Here and
I'll
now
do
I
it.
say, Lord, that I bow down to
So
what
that
has fallen from you.
It's about me. It's not about Mr. Mukesh.
Because in any case, even if it is it has to be in the phased manner,
Hmm.
we'll begin with day. So
Yes.
17th is not a problem. 17th
No.
we'll be having it. We can then
Absolutely.
decide it. But
Absolutely.
then for the time being, let us proceed with this.
The
My
last Lord, the 10 days when he was
Arey,
here
বল না,
during the
দুটোর সময়
winter
আসছি।
vacation, Lord, during the daytime visit, nothing has happened. There is no incident. The child was happy.
আমি
But
আসছি,
only,
দুটোর
Lord, the
সময়
thing is
আসছি,
that the
প্রবলদা।
mother
I'm
is Lord
coming at
averse
2.
to Lord, the child staying
He's
back in
coming
the.
at 2 physically, he says.
Huh?
I'll come at
That's
2.
the threat, Lord.
I'll come.
Grateful. Grateful.
Grateful to Rachel. Great.
কল করবেন দুটোর সময় রাখ। হ্যাঁ হ্যাঁ দুটোর সময় রাখতে হবে তো।
I am for the petitioner.
These custody matters are difficult matters. Very difficult
My
matters.
lord, kindly see the entire order sheet. I have typed it out, my lord. I have obtained the certified copy. My lord, kindly see. The first order is, my lord, 2nd of June 2022.
What has happened? What has happened, Mr. Mahato? What has happened?
My application for recalling of the order fixing expertise hearing, that has been rejected.
And why was it fixed for expertise hearing?
My lord, the next date, my 16th is the next date, my lord.
No, why was it fixed for expertise hearing? What have you? Why
My
have you
lord,
not
there was a
appeared?
paper publication. Prior to paper publication, someone was not served upon me from the order sheet, my lord. I have therefore I handed over entire order sheet. There is no report that it was attempt to be served. That was also not there. My lord, kindly see order number 1. It is the direction for service. Order number 2, no service return. Order number 3, my lord, the state respondent appeared, but my lord, no service return on the defendants number 3 to 9. My lord, there was direction for fresh step. My lord, kindly consider this. On, my lord, 7th of December 2020, there was a direction fresh service.
What is this suit for?
Suit for declaration of right, title, interest, and injunction. Well, in spite of, on the next day, my lord, he has come with a proposal for paper publication. Without filing an application under Order 5 Rule 20, directly, my lord, come for paper publication. That was accepted. Paper is Agdin, which is not well circulated in the area. My lord, it was not within my knowledge. After getting knowledge, my lord, I have made the application that kindly recall the order for expertise hearing. That has been rejected.
Application for substituted service was not filed.
No. My lord, kindly see that. Therefore, I have handed over entire order sheet. All orders are there. My lord, order number 3, direction for fresh service among the other defendants. My lord, got it. Order number 3, 7 December 2022.
Yes, yes.
Plaintiff is to take fresh step on the other defendants. Next date, my lord, for fresh step. Order number 4. Order number 5, today is fixed for taking fresh step. Defendant, plaintiff file draft copy of paper publication. Suomodo.
This revisional application.
No, my lord, on the last occasion, my lord, we were directed to serve the order to the opposite parties, and this is the sixth time, my lord, we are serving this. However, opposite parties are not appearing. My lord, in that respect, my lord, I am filing my affidavit in compliance, my lord, affidavit of service, complying to the last orders, my lord.
What is the matter?
My lord, the matter is about, my lord, the impugn order, my lord, where my order 6 rule 17 application, my lord, was rejected.
Order 6 rule 17 for
My lord,
what?
for amendment of my application under section 8 and 9 of the West Bengal Land Reforms Act, preemption application.
Case.
Yes, my lord.
So amendment of plaint you want?
Yes, my lord. Now, my lord, what has happened? There
Why
was
it rejected?
My lord, it was rejected, my lord, on the basis that the trial has commenced and it matter was reserved for judgment. However, this.
Why did you not come earlier?
No, my lord, what has happened in my pleadings, I have mentioned that certain plots of land that were inherited by me. However, subsequently, my lord, this is a deed of settlement of 1988, 89, registered deed of settlement. We have found it was misplaced, and since the pleading was not that it was misplaced, therefore this order was passed, whereby my order 6 rule 17 application was rejected, stating that it has no consequences whatsoever in the adjudication of this application. Well, only the document we want to incorporate, my lord, for the proper adjudication of this instant matter. That's it. And however, my lord, the inheritance of the plots are not being challenged by the opposite party in the written objection.
But you have to show due diligence. After trial, it is now settled by Supreme Court that the trial court has to reach a satisfaction
that you
could not produce it because of due diligence, and that has been held to be a jurisdictional fact. The trial court will assume jurisdiction to allow amendment after trial only if the trial court reaches this conclusion that you could not have produced it despite exercise of due diligence. Where is that in your application?
Well,
the application to succeed.
I'll just
That should be the
indicate, my lord,
only
that page 32 is my application, and it's in, my lord, vernacular, my lord. Only the pleading of misplaced, my lord, as it appears at page number 33, my lord, it has been mentioned. Only, and if lordship kindly comes to my main application where I want the incorporation, my lord, at page number 19. This is my application under section 8 and 9, my lord. At paragraph number 6. At paragraph number 6, page 20, your lordship will find my pleading regarding that the adjacent plots have been acquired by me by way of inheritance. And in place and instead of, my lord, that pleading, my lord, this has to be incorporated that it has been my lord, by way of inheritance, by way of this settlement deed, my lord, we have acquired this property. However, my lord, in a similar situation regarding two other plots, my lord, this learned court has held that it can be allowed with a cost of 4,000, my lord. Same parties. I'll just indicate, my lord, this is the order that was passed at copy dance. Same deed, your lordship, due to misplaced deed of settlement, this has been allowed.
So your original case that you had received it by way of inheritance still remains?
Yes, my lord.
Your predecessor in interest had got it by way of settlement, and from them you have got it by way of inheritance.
Yes.
So it is more in the nature of a clarificatory amendment.
Clarificatory. Will it be my lord's pleasure to allow me to rely on a judgment of 2022 My lord is aware, my lord, life insurance versus Sanjeev Builders, where my lord, the principles of Order 6, Rule 17 has been summarized, my lord. From my lord, if your lordship allows me, I'll go through it, my lord. Kindly allows me to, my lord, go through, my lord, paragraph 71. Correct, full 71. Full. The From 71, your lordship will find our final conclusion may be summed up by this. 71.1, my lord, will kindly ignore. And therefore, after 71.2, my lord, will kindly allow me to. All amendments are to be allowed which are necessary for the determining the real question in controversy, provided it does not cause injustice or prejudice to the other side. This is mandatory as it apparent from the use of the word shall in the latter part of Order 6, Rule 17 CPC. The prayer for amendment is to be allowed if the amendment is required for effective and proper adjudication of the controversy between the parties, to avoid multiplicity of proceedings, provided that the amendment does not result in injustice to the other side. By the amendment, the parties seeking amendment do not seek to withdraw any clear admission made by the party which confers the right on the other side, and the amendment does not raise a time-barred claim resulting in divesting the other side of a valuable accrued right. A prayer for amendment is generally required to be allowed unless by the amendment a time-barred claim is sought to be introduced, in which the case the fact that the
Now
claim
the
would
case
be...
is fixed for arguments.
Yes, my lord.
Evidence is closed.
Evidence is closed, my lord.
Then, after you amend the plaint, they will also get a chance to amend the written statement. Whatever less the amendment is, the evidence will again have to be relayed. What about this?
My lord, in a similar case, that was allowed, my lord. They were allowed to file a written
ground.
objection, additional
It's not a ground to allow this, but what should be the case? The entire
that
clock
will be
have-
again reopening of the entire trial.
entire clock will have to rerun. Because this is after closure of evidence at the time of argument.
My lord. This is a, my lord, tricky situation.
And why do you think that this amendment is necessary? What will happen? You will not be able to prove your case because of this.
No, my lord, that is not the case, my lord. But however, my lord, there can be a question of title at any point of time, my lord. At the time of argument as well, there can be a question of title, my lord.
लिखे नहीं this revisional application
one thing, just I will take 1 minute. My lord, item number 14 today, my lord, it is running in the new motion, but it is actually contested application running in the Bandi disk, my lord. I don't know how it has come, my lord.
ঠিক আছে থাক ওটা কন্টেস্টেডে পাঠিয়ে দেবেন উনি যদি
My lord, and every day, my lord, I am coming, my lord.
you had prayed for upgradation.
This is the order, my lord. When
You might have prayed for upgradation.
Application.
Upgradation
No, I did not mention, my lord. That is a surprising matter. And probably
This is the
it was
mentioning
mentioned by the proforma respondent, my lord, not the principal respondent.
Very well. It is there whenever it is called. Please
So let the
be
matter
ready.
drop, my lord. List থেকে এটা যাবে তো?
না না যেখানে আছে সেখানেই থাকবে. Wherever it is, it will remain. Doesn't matter even if it is contested or new motion. How are you prejudiced?
These old age, I am coming, my lord, every day. That's why I am mentioning, my lord. Nothing more than that.
Even if it is there in the contested list, it can be taken up, sir. Yes.
Before my lord takes up, my lord, today there's a fixed matter, 311, my lord.
My lord, matter.
That right of preemption, Mr. Chaudhary had argued, my lord. I am told Mr. Nimesh.
I turn to reply.
I'm told Mr. Nimesh Mr. lost his mother today at 12:30. So he won't be there for a while.
But he was supposed to.
Yes, my lord.
Answer.
He keeps it after the vacation. Any
Very well. 311 after vacation.
My lord, that order which lordship had passed, recording that they will not take steps.
Yes,
before
my
the
lord.
matter, let
We
that
shall not
continue till my lord.
Yes,
the matter is
Yes,
heard
my lord.
by
We
the
shall not.
লিখে নিন একটা order লিখে নিন। I'm recording your consent to that. I'm recording your consent to that, Mr.
Yes, my lord. We shall not.
Lordship's order was dated 6th of May 2026.
একটু দিন তো ফাইলটা দিন।
Mr. Chaudhary has already concluded. It's my turn to reply.
Yes.
Yes. No, the reason means.
লিখে নিন। You are Mr. Chatterjee?
Yes, my lord. I'm Mr. Chatterjee.
লিখুন। Mr. Chatterjee, learned advocate appearing for the opposite party number 2, seeks an adjournment. Full stop. He submits that his leader
Copy may be served upon us.
When can we have it next?
May any day next week. Now I'm less busy.
But before the vacation,
But I'll not take maximum 30 minutes, maximum. That is the outer limit. Maybe 20-25 minutes I'll finish.
then can we have it on the last day?
Before the vacation.
Because that, yes, because that
Because
will be a easier day.
I understand.
I'll conclude then.
Then 2 o'clock on
Or
the last day.
even if I don't conclude,
What do you mean?
I'll keep it for clarification on the next day, and in the meantime, I'll also get ready. Second half in the last day is supposed to be a lighter half.
Yes, yes. But I have no difficulty, but Mr. Ghosh may not be able. Agree. ठीक है. Last 22nd, 2 o'clock.
2 o'clock.
No, you kindly take this on record.
हाँ,
I have
अच्छा,
served
ये-
the others. Yeah? No, no, it is
Fully
completely
did.
available.
এটা কত নম্বর আইটেম আছে? 293 তো একবার কল করে দিন। 293 না তো?
96. আমি আছি।
296 হ্যাঁ। হ্যাঁ, ফাইলটা একটু দিন। একটা শুধু অর্ডার শিটের ফাইলটা দিন অন্তত। কিছু একটা দিন। খালি খালি অর্ডার, হ্যাঁ একটু কিছু দিন। লিখে নিন দাদা, জানাদা লিখুন।
তুমি আমাকে স্ক্যান করে দিন।
Milord, yeah, it's a little. He's insisting on Milord the nights being Milord with the mother. He's insisting on that. Your Lordship wants a transitional. For the first 5 days, keep it with night with the mother. Then, if the father Milord can convince him, the mother will not stand in the way at all. Starts off with that, and the problem which the mother told me, and don't take it as a Milord as a spanner to the wheel, is that if there is a trigger, then they will not be able to handle him. And that's an apprehension. So the mother will be around somewhere, will not in any way come anyway close to Milord when he's with the father. Just in the evenings, after the parties, everything, not even fix a timeline, it's fine with us. He wants to take him to the club, anywhere he wants to take him. First 5 days, let him spend with the mother, and mornings he will go to the father. No timelines. So after the parties are over, the clubs are closed. I'm sure the clubs which are open after 11:30, I'm sure Mr. Mukherjee will not take my child there. So after that, let him come back, let him relax, and then go back again.
So far as the proposal that comes, it will be an open the time period, but the child will go back to the mother for sleep. Your Lordship may put that, But Lord, do not Lord, put anything, Lord, in the option of the child or Lord, the discretion of the child or the mother, that Lord, for this other half, Lord, the child will have an option not to stay with the father.
No.
That will give him, Lord, a handle.
I bow.
Then your Lordship will kindly make it that the
It's
first
not-
5 days, Lord, I will have the child. He will go back, Lord, for sleeping with the mother in the night. And for the
That's a fair
next 5
suggestion, Mr.
days,
Mukherjee. Thank you.
and
Because
Lord,
I was also worried from the court's point of view. I will be more concerned about the child's health.
we all are in
Now,
fact.
yes, of course.
We all are.
Father,
Lord, it is
father and
not
mother
about
would
Lord
be
that the father and the mother fighting, it is the child.
Because there are documents on record which show that if you see this, because yesterday I went through this. I'll just indicate a few things.
The two things, Lord, kindly Lord, indicate where the mother will be staying, subject to Lord, they intimating the court. Also, Lord, that at what time, Lord, the child will come. The end time is not specified, but he will go for sleeping with the mother, Lord, wherever the mother is staying. And Lord, for the next 5 days, let him stay, Lord. I'm also a father. I will also consider, Lord, if he is inconvenienced for some reason or the other, or I cannot handle,
it.
Lord, I will certainly, Lord, not Lord, impose upon the son.
Even from yesterday, I've been saying this. Absolutely.
Possibly not yesterday.
Please help proceed with the order, Mal.
Because Lord keeps it as short and simple. Yes.
Yeah. I'm sorry, Milord. Yes, yes, we were following, Milord. Now it's very easy to follow. Because wherever you are, just keep it open on the phone, and when your lordships rise, I know you can run. Oh. So then some other day.
Well, the only thing is, well, there is a, well, your lordship will observe that on the next day they'll take adjournment.
Yes, now we have to.
Well, so far as that is concerned, well, only, well, provide for that, because otherwise.
No, I totally
well,
understand. We
have
took a
no
chance.
pressure on your lordship.
Absolutely not.
Well, only
And,
while it's interim protection, I think we have both agreed on
of
that.
course. We'll take an adjournment. Your lordship need not, my lord, concern yourself. Lord, we'll do the needful.
Next week we'll take action. Again, but same notice.
Yes,
Yes,
my lord, but my lord, only, my lord. No,
Absolutely.
but there's no difficulty. Only, my lord, your lordship will provide that on the next day they'll take an adjournment. That is
No,
all.
I am saying I will. I am saying I will.
Well, whenever it is convenient. for you.
Whenever convenient, my
My
lord.
lord is coming back on the 9th day. After the 9th. আরে দাঁড়াও না, করছে যা করার।
Lots of uncertainty. বুঝতে পারবো তো গন্ডগোল হয়ে যাবে করে দেবে না
Hey, your lordship has provided that, my lord, one adjournment.
Yes, Milord, I will go and do it.
ঠিক আছে, আর কিছু দরকার না, তো হইতে করছে।
Yes.
Yes.
One to four. 1 to 4. On the next day.
Yes, sir. Grateful.
Grateful.
I appeal for the defendant. There are two applications. One is the application by the plaintiff for injunction, and my application is for acceptance of the written statement. Mr. Nirmalla Dasgupta was appearing for the plaintiff. Yes. Yes.
Because of the resolution also, I will not be able to take.
Yes,
this
I understand.
Won't be proper.
Yes.
लिखे नहीं. None appears. for the plaintiffs, full stop. Mr. Shurajit Dasgupta is present for the defendant, full stop. For ends of justice, let this matter stand adjourned and be listed immediately after reopening of the court after the ensuing summer vacations.
Great, great.
Next. After summer vacation, কোনো ডেট দিইনি কারণ আমিও তো জানি না কবে বসবো লিখে দিয়ে দিন প্লিজ keep a watch on the list. Yes, whenever I take specially assigned it will appear. লিখে নিন একটা অর্ডার রেকর্ড করেন বসে বসে লিখে নিন তা অ্যাডজয়েন্টমেন্টের অর্ডার none appears for either of the parties. For ends of justice, let this matter stand adjourned and be listed immediately after the ensuing summer vacations. Yes. Same order. Same order.
Wait, please, my learned seniors are online. So that.
Lords, I beg to appear. This is, my lords, writ petition seeking a crystallized refund. Lords, the income tax department quantified a refund of about 9.43 crores. Lords, as back as 15 January 18 and then, my lords, on August and November 24. However, my lords, there is no order, my lords, either adjusting this refund or not granting it. We have repeatedly written to them. Mullahs are aware under 245, either they can adjust the refund or they can pass an order withholding the refund. They have to do something. Because unfortunately, nothing is happening. And what the interest now on the principal amount is almost the same. The refund is now about 18 odd crores.
Nobody is appearing for the department.
But I believe it's because of the
resolution. What to do?
Because on the
and this is an assigned matter, so
Honorable Justice Smita Das, they was pleased to release.
Yes.
The respondent's advocate was pleased to enter appearance, and I had spoken in the morning. I believe it was because of the.
Serve a notice on them. I'll take it up immediately after reopening.
May I request, our Delhi vacations start on the first week of June. Could Mallods have it in the last week of June if convenient to Mallods?
Not a problem. We can have it in the last week of June.
I am very grateful.
I will also provide a copy of today's order.
Please, Likheni.
I'm so.
This is an assigned matter. Now, this matter has been assigned to this bench by the Honorable the Chief Justice. Full stop. While the petitioner is represented through Mr. Sachit Joli. Mr. Sachit Joli, yete dekhe neben naamta onar. Learned senior advocate, comma. There is none to represent the respondents. The petitioner shall serve a notice on the respondents. Full stop. List this matter.
It was 24th or 25th, if Mallods, it's convenient, of June.
Very well. It's 24th June. I'll do this. Maybe in the meantime, even if you're not there, the learned advocate assisting you over here will be here.
Please,
because fixing such a long deck won't look nice. I may ask them to come with the instructions, and that may serve your purpose in the meantime.
Please, Mallods.
List this matter immediately after reopening of the court after the ensuing summer vacations. In the meantime, you serve notice on them. Once it appears, I may ask them to take instructions and inform, because that will expedite things.
Yes.
Because this is going to happen again on the day when the matter will be finally appearing.
I realize that.
My lords are absolutely, in fact, my lords, I can point out this very same issue. The company, we file now petitions in almost every high court. We've succeeded in 3 high courts. We are now before my lords in Calcutta. I'm so grateful. I'm so
also provide a copy of today's order.
Yes. Grateful. Thank you. ওই সেম অর্ডার করে দেন না পিএস রাইট ঠিক আছে থ্যাংক ইউ এই অ্যাপিলেট সাইডের দিদিকে কল করে যদি কিছু কেউ থাকে ওনার ইয়েস স্যার
My lord, yes, my lord, appellate side matters, my lord, item number 400, my lord, extension for interim order, my lord.
No, your other side?
I do not know, my lord, the order has been passed on Honorable Justice Samba Sarkar on 23rd to
I understand,
2026,
but,
3 months extension. Now, the month is going on. Next month, the matter will be coming into the
Not a
telco.
problem. I am here even in the next week. I'll be এটা একটা কাজ করবেন এটা সোমবার দিন ওই ফার্স্ট হাফে রেখে দেবেন ওই 12:30 বা ওই রকম সময় এক্সটেনশন গুলো কয়েকটা তো আছে হ্যাঁ কয়েকটাতে আছে তাহলে শেষ হয়ে যাবে কারণ ওই 3টে 3:30 হয়ে গেলে সবাই চলে যায় ওই 12:30 থেকে 1টার মধ্যে থাকলে সবাই আসবে আর যদি নাও থাকে আমি এক্সটেন্ড করে দেব on Monday I'll bring it in the first one. That will help you all. I don't want to keep it at 10:30 as usual as is usually done because everybody comes and argues and then it is extended ultimately so it wastes time so I kept it so that
that will reflect in the list, cause list. Much obliged, I am grateful to you.
এটা মনে করে কেটে দিয়ে 12:30 করে দেবেন নালে 3:30 থেকে গেলে আবার ওই জিনিস
Monday there is a possibility of 3:30.
আর কেউ expeditious disposal কেউ আছে তাহলে করে দিন থ্যাংক ইউ
Lordship, today my matter was listed at CL number 15, but unfortunately, but unfortunately it was not. It cannot be taken anyway. I just want to recall the matter. It was last heard by by your Lordship on 24th of March, and this Honorable Court has directed me to file the compilation of judgment on the matter of maintainability, which I have complied. And I just want to intimate because your lordship has said that you also want to see the judgments what I have. So I have already filed the first. I had filed the judgments that is from Indian Kanun, but later
Not a problem.
No, but later I have heard that high courts are not. I have also filed the SCC and AI today, sir.
Very well. Not with this case. Whatever is convenient to you, you can file. I go through all papers. Not a problem.
Okay, but I have already filed it.
If you have done it, not a problem.
I have filed it today. Filed it today in the filing section. And sir,
সেকশনে কি ফাইল করেছেন তাহলে ফাইলে এনে শামিল করে নেবেন কারণ তো ফাইলিং
and I want to not place this one. I want to make it not place the
once it comes you
right.
take it.
And your lordship. Yes,
ওটা ফেরত দেবেন না এখন রেকর্ডের তো
I want to not place this one. This is the earlier.
Very well, not a problem. Please give it. It will form part of the records since it is there on the record.
And the matter will be when it will be kept, your lordship, if you.
It is there in the list.
Okay.
It is there in the list.
Grateful, your lordship.
If it is extension, then both sides will be required. If it is expeditious disposal, I can
expeditious disposal, lordship.
তাহলে দেখুন ওনার যদি কিছু
Item number 394 and 395. 395. One five three. Lordship pending before the CO 1538 and 40 1540.
পাওয়া যাচ্ছে না? তো নেই।
For argument.
কেন আসে না কেন? আমি যখন বসে থাকি তাহলে তো চলে আসবে। তারপর অরিজিনাল সেট নাও চলতে পারে।
Last date
ছুটি নেওয়ার কি আছে? আজকে তো সারাদিন এমনিতেও খালিই ছিল। হুম? $394 394 এ লিখে নেন, হ্যাঁ। 394 is a probate case.
Yes, Lordship. Next date is 11/6/2006
This
for
original application seeks expeditious disposal of probate case number 8 of 2017 pending before the learned district delegate, Purbo Medinipur, Tomlu. Usual paragraph টা মনে আছে? Usual paragraph? হ্যাঁ, মনে আছে না নেই? ওই সার্ভিসের ব্যাপারে যেটা। হ্যাঁ, তারপরে having heard the learned advocate appearing for the petitioner and having perused the material on record, this revisional application is disposed of by requesting the learned district delegate, Purbo Medinipur, Tomlu, to dispose of probate case number 8 of 2017 as expeditiously as possible and preferably within a period of 2 months from the next date fixed without granting any unnecessary adjournment to either of the parties. ঠিক আছে?
Much obliged, Lordship.
Next.
Next matter is 395.
লিখে নিন।
Police help pending since long time. Lordship, kindly direct.
Application for police help.
Police help.
This revisional application seeks expeditious disposal of an application under section 151
Lordship.
of the Code of Civil Procedure, 1908, filed in connection with title suit number 136 of 2020 before the learned civil judge, senior division, Diamond Harbour, seeking for police help.
Next date is 7 July
Full stop
2026.
paragraph, usual paragraph. Having heard the learned advocate appearing for the petitioner and having perused the material on record, this revisional application is disposed of
Let my senior
by requesting the learned civil judge within bracket senior division, Diamond Harbour, to dispose of the pending application under section 151 of the Code of Civil Procedure as expeditiously as possible and preferably within a period of 2 months from the next date fixed without granting any unnecessary adjournment to either of the parties.
Much obliged.
Next. আর কেউ নেই তো?
May I be permitted to mention item 337 of today's list? 337. This application is filed seeking for an expeditious disposal of the title suit 275 of 2021 pending before the learned 10th civil judge at City Civil Court.
আর কেউ নেই তো?
I want madam expeditious disposal 345 if you're not.
Give your numbers first, because
345.
if you wait and then call, I'll also have to wait.
345.
I was in division bench. I came at 4. ঠিক আছে, as requested by the parties করে দিন। Inform Mr. Datta.
I had talked with him. We just left that.
Please inform me, because in front of him ওটা রেকর্ড করে দেবেন, as requested by both the parties. List
345
as requested by both the parties, list this matter after the ensuing summons.
Otherwise, I don't miss matter.
লিখে নিন দাদা। This is CO 328 of 2026. Madam, 328, CO 328.
Yes, Lordship, 328 of 2026.
Revisional application 6, expeditious disposal of title suit number 275 of 2021, pending before the learned judge, 10th bench, City Civil Court at Calcutta. তারপরে usual paragraph. Having heard the learned advocate appearing for the petitioner and having perused the material on record, this revisional application is disposed of by requesting the learned civil judge, requesting the learned judge, 10th bench, City Civil Court at Calcutta, to dispose of title suit number 275 of 2021 as expeditiously as possible, and preferably within a period of 1 year from the next date fixed,
Lordship also direct them not to give
without granting any unnecessary adjournment to either of the parties. CO such and such.
much of.
345.
Much of.
My lord, I am for the petition here, my lord, petition for recovery of possession, and it's a matter of peculiar case, my lord, petitioner purchased from the respondent, and for handing over possession, but till date he is not handing over possession since 2020. I filed this suit for my 2022. Till date, my lord, they are taking adjournment.
What is the stage?
The stage, my lord, for injunction and nature, change to nature and character of this. Yeah.
Same order ही হবে, title suit number টা
Title suit 910, my lord.
same order করবেন, 910 of 2022, pending before the learned civil judge,
Civil Judge Senior Division, Barasat.
Third Court at Barasat. এই নাম্বার চেঞ্জ করে দিলেই বাকি সব সেম হয়ে যাবে।
Well, within, my lord,
Within
1 year.
from the next date fixed, without granting any unnecessary
Adjournment within 1 year.
আর নেই তো, উঠে যাই।
I often mention every day morning.
Yes, I see your
that-
date
that
is
this-
21/6,
Is it
not
counting
before the
now?
vacation.
Yes, the difficulty is that I showed my lord list. Despite that, despite showing my lord list, it was
Immediately after reopening, I have indicated it to
no.
them
The difficulty is that they have already written 2 mails to the arbitrator that my lord had refused as not upgraded.
If it is on 21/6.
Yes, it is on 21/6.
So before
Any day, prior to 21/6,
I'll have indicated.
kindly fix it any day so that it can be hard. Otherwise,
yes.
I am non-suited.
It will be upgraded. I have indicated it to.
It is item 181.
It will be there only. It will be upgraded at the right time, because today all those matters were upgraded whose dates were on 16th or
Yes,
18th.
yes. I had not, for that reason, I had not bothered your lordship in the morning.
I know, I have
Difficulty is
seen
that
it. I go through the list. I go through the lists every day. That is why I
Yes.
remember your dates. I remember everybody's dates, whoever has mentioned.
Kindly, any day prior to 21/6.
It will be taken up before the date. হ্যাঁ তো ঠিক আছে, যত হলো হলো, তো আমি তো এসে বসলাম।
Done.
Thank you.
Let us